Yes. Hello, my beautiful friends, and welcome back. We have a tremendous live stream planned this evening. We've got big updates out there. One happening at the Supreme Court of these United States. The president and D. John Sauer, the Solicitor General, are going and providing an update to SCOTUS as it relates to our elections. We had a big rule drop at the end of last week on the U.S. Postal Service regulations. And now we've got the battle between the DOJ and the judges brewing, making its way to SCOTUS. We'll see if this week we get an answer from the Supreme Court. We've then got some updates on Ilhan Omar. This one is very curious. There's kind of a confirmation by implication that she is under investigation. And I found this old letter from her. She was very upset that apparently there was an undercover agent surveilling her right outside one of her events. And so she fired off a letter saying, why is this happening? And was demanding answers from local authorities, the local FBI building, the agent who was there. And we'll take a look at exactly what's going on and why Ilhan is in big trouble. We also have a major update on the H1B situation. We have another $100,000 fee that will be assessed and a bunch of justification for why it is lawful and perfectly legal after the last attempt was slapped down. And then the commie Mamdani is now getting hit in two separate lawsuits. Furious New Yorkers are unleashing against him. We know that he's trying to install some communist grocery stores out there in New York. And the problem with that is it's going to undermine a lot of the other grocers. And so we'll take a look at exactly what's going on there because many of them are minority-owned businesses, and they are not happy with this new plan. So it's going to be a beautiful stream. Thanks for sticking with us to the end, and we'll take your questions and your comments, and of course, see what you have to say about all of this. Looks like the tubes have connected beautifully, and that means we can go ahead and get started, starting with the Supreme Court. And as soon as we get Mamdani off of our screen here and fix this freeze, which sometimes happens, this is where we want to begin, starting with the Supreme Court. The Trump administration knocking on the door of the Supreme Court saying, we need you to decide this matter now. We've got elections coming up and we've got lower level judges blocking all of our efforts to fix some of the most serious problems that we've seen happening throughout the processes. We have this one document that is now going up to John Roberts coming out of, actually, this will be going to a different judge, coming out of the case of Trump and California. We know California sued the Trump administration as soon as the executive order came down that was going to fix our elections. We've got two main components to that, the citizenship list and, of course, the Postal Service regs, which are not going to be all that different than what we currently have in place. We just want to make sure that we're not committing mail fraud by sending in illegitimate ballots. And so a new rule came down from the Postal Service. We'll take a look at it. And what happened in the aftermath of the new rule that has come out, you can see here, they articulated it for us right here, the public inspection.federalregister.gov website is where they're referencing us to. And what this is going to show us is that there is some things that are happening, some changes that are being made, but not that big of a deal at all, really. And this begs the question, why are these judges so irritated about it? So we've got a new order that came down from Judge Indira Talwani, the Obama judge out of Massachusetts. And she said over the weekend, she was furious because the Postal Service rule dropped on Friday. She came out and said, I said you guys shouldn't be doing this. And here's what she wrote in her order. She said, you know, on August 11th, some time ago, I, Judge Indira, entered a preliminary injunction to prevent irreparable harm to the plaintiffs. And in this case, we've got Californians suing. We've got a bunch of people suing. We've got the NAACP suing in another case. We have the League of Women Voters in another case. Many plaintiffs all came out to go and attack this executive order because they hate election integrity. They love the rigged system. They don't want it to change at all. So in this one, let's not forget how ridiculous this whole thing is. She said the irreparable harm is going to be to these organizations who are seeking to educate their members about the status of mail-in ballots relating to the November 3rd election. So in Massachusetts, we've got the League of Women Voters who are suing to say, if you make these sudden changes, we're going to have to update our websites. We're going to have to educate our constituents about changing how they go vote. And so that fact alone, in other words, the government changes something, and so the literal entities whose entire job is to help interface between the government rules and what their voters are doing, they're going to have to do their job. They're going to have to connect the dots between the two, make some changes, and that will be irreparable harm. They'll be all blown out. They won't know what to do. Updating their websites, very difficult for them. And so we have now blocked you guys. Also, it's going to limit the implementation of the rule, and it's going to ensure an orderly review of the rule from the Postal Service after it's implemented. It's also going to avoid confusion. Everyone's not going to know how to vote because the order is now going to be happening within 90 days of the election. Now, Trump and the DOJ and Homeland and all of these other agencies, Postal Service, did not file an appeal or obtain a stay. But they didn't care. They said, we have a right. This is the executive branch. We run the Postal Service, all delegated to us by Congress. And so over the weekend, on August 21st, the Postal Service issued its final rule. The final rule is going to change a couple things that they don't want to change. So there's going to be an anticipated publication date of the 26th, so a few days from now. And then the plaintiffs, the League of Women Voters, they came back out and they filed an emergency motion. They said, you have to do something about this now, Judge, because once the final rule comes into play, this is the little legal caveat that they're so nervous about. Once the Postal Service issues a rule, by statute, the law says that you got to go through a postal board to challenge the rule. You can no longer go to these activist judges and ask them to step in and stop the executive branch from doing their job. So they need the judge to block it now, because if it goes too far, then the court is going to lose jurisdiction. So defendants now oppose that request, the Trump admin, asserting that their action will have no effect on the rules themselves. And of course, once the rule's in place, we're not going to actually enforce it, saying that this is missing the mark, says the judge. This is going to ignore the confusion. Even posting the rule, even though they're not going to implement the rule, is going to cause that confusion. So you can't do that. Now, you get only 2 days to respond. The DOJ said this is ridiculous, but she writes, the Postal Service, you created the emergency. You issued a rule on Friday evening after the courts were closed. So now you need to file any response by August 25th and allow this court 1 business day to address this. And alternatively, I will extend this a little bit, but you have to agree that you're blocked. So if you seek the August 27th filing date, then promptly advise the court of what we're going to be doing. So this is in the Indira Talwani case. You can see this is being litigated for a long time, a lot of scrolling going on. All these are lawyers and amicus briefs that have all been filed. And the states have also intervened in this. So we've got this situation now where we've got California and Team Blue versus Team Red. Oh, look at all these lawyers. It's just ridiculous. In this case, it's the League of Women Voters versus Trump. In the other Supreme Court case, we've got California versus Trump. And red states want this to happen. Red states say, we'd like some election integrity, please. Can we have it? We elected the president to, govern and implement these changes, but the blue states say no. And of course, the hack blue judges are preventing it from happening. So that's what's happening out of Massachusetts. Then we go over here. This one is the state of California, same types of issues here. So the DOJ is now knocking on the door of the Supreme Court. They're saying, listen, we need you to help us. And all of these issues are largely interrelated. So they say, all right, Judge, look, on Friday evening, the Federal Register that we're going to look at made available for public inspection a final rule about the mail, the U.S. Postal Service. It's called Ballot Mail for Federal Elections, all now been submitted to the Postal Service. The rule doesn't change a whole lot. All it does is amend the domestic mail manual for all of our Postal Service folks to impose modest envelope design requirements for federal ballot mail. That's it. We're just going to change the envelopes a slight little bit. The rule was issued pursuant to our rulemaking authority. U.S. Code says the Postal Service can do this, and operational authority under a different provision. Scheduled for publication this week. It's going to be the final rule. And again, once the final rule is implemented, then they're going to say, you actually can't sue us here. You have to go through the Postal Service board and sue there and lose there and then go to the Article 3 courts. So the final rule, all it does is this. It requires federal ballots that are transmitted through U.S. mail to be mailed in envelopes that include official election mail logo. So it's treated like a little extra special. Are automation compatible and use unique barcodes so we can track where they're getting picked up from and where they're going, that denote the item status as federal ballot mail and its delivery point and zip code, which is what they don't want. They want it to be a free-for-all, because if you start to track the barcodes and you say, that's interesting. There's only 500 people in the zip code, but we picked up 2,000 ballots. How's that work? It would mean you've got duplicative ballots getting sent in from there. So you can now start to connect the chain. State election officials must submit their envelope designs to ensure compliance with those requirements and provide the Postal Service with a list of the ballot mail items that it intends to send. Now, that list must contain the unique barcodes assigned to each ballot envelope, along with the name and address of the recipient and the state sending the ballot. State officials may continually update their lists as necessary. And when state election officials present their outbound ballot mail for mailing, so the states then gobble up all of the ballots that are going to be sent out. All they need to do is make sure they're marked appropriately, and the Postal Service will verify that the envelopes comply with the rules design requirements, such as inclusion in the list submitted by the states. Now, the Postal Service will not perform any verification of voter eligibility at all, or the like. Its role is limited to ensuring that the envelopes comply with the rules design requirements. That's it. Now, on or about the date of the relevant election, the Postal Service will provide each state that use U.S. mail, it's federal mail. You can't send crack cocaine through there. You can't send other fraudulent items through the mail. The mail service is not supposed to be facilitating crimes. To transport the ballots, we're going to provide to each state that used us a single list containing all of the state's submissions regarding ballots sent. So the issuance of a final rule now underscores the need for relief. We need you, Supreme Court, to let us continue with this. We've been blocked by these lower level judges. The court has issued an improper, unripe injunction, blocking us before the rule is even out. And if the rule's not out, and the standard for a legitimate block on injunction is some level of irreparable harm, what is the irreparable harm if there's no actual change that's been made yet? Now, as the rule itself notes, the Postal Service cannot implement the rule as to the November 2026 federal election without relief. We are just publishing this. We can't actually implement it because we're blocked. It's in the rule. But the judge is now saying you can't even publish it because it's going to cause the confusion. So, and contrary to the district court's assumption, the published final rule does not simply mirror the proposals in Trump's order. It's different. Trump issued an order, and the rule is actually less aggressive than what is in the order, which I think is by design. This is a strategy to just kind of chip away at this. Let's get something through that is a lot more benign, that is a lot more accessible and acceptable to the courts and to the Supreme Court. And then once we get that precedent is ensconced in the history books, then we can start to just add in a little bit more. We make a pizza, add a little pepperoni in, add a little sausage, add a little onion, add a little whatever you want on there. And lo and behold, now you've got the works. So, for example, the Postal Service will not refuse to transmit ballots from people who are not on the state submitted list. We were originally going to be creating a citizenship list, and only if you were on that list would we pick up your ballot. Not going to do that. All we want to do is just put some barcodes on there and kind of just track the flows a little bit so we can see what is being gathered and what is being delivered, what's being sent and what's being received. But the injunction from the lower courts nonetheless precludes the rule's implementation in the respondent states based on the court's assessment on the order's proposals and the potential implementation, not on the content or the actual application of the rule. Nothing is actually in effect. So we can't even talk about it. Now, the Postal Service's final rule imposes only modest requirements for preparing the envelope for actual federal mail, requirements that fall well within our traditional authorities to impose mailing standards, and to do that for particularly sensitive types of mail, ballots, of course, being included there. So in prejudging the merits of a hypothetical rule, with provisions the district court could only speculate a final rule might contain, the district court seriously overstepped the bounds of longstanding Article III standing and ripeness principles. Should respondents nevertheless choose to challenge these modest requirements of the final rule, the lower courts are the proper forum to address those questions in the first instance. And so a stay, writes D. John Sauer to the Supreme Court, of the lower court's injunction would allow the district court to adjudicate any challenges to the final rule and would permit any further appellate review as necessary. Signed by D. John Sauer, Solicitor General, and saying, actually, once it isn't implemented, they can still litigate over this, but they can't block us from implementing it. It has to go into effect right now. And we'll see about it. But if that does ultimately happen, I think we might see another argument that there is the lawsuit is now proceeding in the improper forum, and they need to go through the Postal Service Regulatory Commission first before they can actually reach the Article 3 courts, because the Postal Service has a governing body. If you have a complaint against the Postal Service, just like many other entities, you have to go through these other forums first before you go into the Article 3 courts and sue. Just like with if you're a federal employee and you get fired, you got to go sue in and make your complaint in a separate body before the Article 3 courts are available to you. So that all goes up to the Supreme Court right now. And while we're talking about the Postal Service and everybody's saying, oh, the Postal Service is trustworthy and they're incredible people full of integrity, we just learned that some Houston postal carriers not long ago just got indicted, 5 of them, I believe, now charged with multiple crimes for stealing checks out of the mail to the tune of $23 million. So all you got to do is substitute checks with ballots, and you can see what a big problem this is. So here's this story over from ABC out there in Houston, Texas. 3 Houston postal carriers among 5 people charged in a check theft scheme that landed the alleged crooks more than $23 million. Wow. ABC 13's Tony Atkins has more on why investigators say this alleged scheme went on for nearly 6 years.
Investigators say that postal carriers were recruited to find and steal checks, and then those checks were then sold on the internet, and now the suspects, 5 people indicted for these charges.
5 people are now federally charged for allegedly stealing checks in the mail and selling them to buyers. Investigators say this 5-person indictment runs through this man, Tristan Vaughn, who allegedly recruited mail carriers to steal the checks. Those checks were then resold over the encrypted Telegram communications app. This court document says 3 carriers took the bait in this scheme, and they are also charged. Records say Catherine Kilpatrick, Jacor Alexander, and Malcolm Joubert were the carriers charged, pulling checks out of the postal system and into the alleged fraudulent scheme. And the indictment says some of these checks were made out for large amounts, including $16,000, $25,000, and $80,000. The largest check investigators say came through for $1.5 million.
Dang.
I think that definitely wasn't right. I feel like that's definitely a given.
Investigators say the stolen checks would then be sold through an encrypted group called Slips and Chips on the Telegram app.
That's unfortunate for sure.
Investigators also say a 5th defendant, Alyssa Bryant, sold a stolen check to a buyer on Telegram for $25,000. The grand total over 6 years, $23 million.
Dang.
23 million is not something you'd find just lying around, even in a prosperous city like Houston, I wouldn't think. So.
I love these little chyrons down here. This guy uses the Postal Service, that is what they labeled him as, uses USPS. Many people do. And again, if they're willing to steal checks and turn that into a business to the tune of $23 million, do you think that they may be willing to just kind of throw out some, Republican zip-coded ballots? Some of the red locations, the red counties just go into the dumpster and nobody can validate that they've been returned, which is why we want to make sure we got barcodes so we can see what the return rates are. And we can see where certain locations have huge batches of returns that maybe don't match the population numbers, or if all of the other counties have, let's say, 60% return rate or 80% return rate, whatever the standard is, and you get something very low, you get like a 40% or a 30% return rate out of one particular location, maybe that's worth looking into.
So they're probably pretty good at it.
Other people we spoke with say they're happy to see investigators track down the alleged thieves. They say hearing about such a thing does give them concern.
Well, it definitely does, instill that bit of fear.
USPS.
Reporting in Houston, Tony Atkins, ABC 13, Eyewitness.
Yeah, not good, not good. So you can see why we want to make some integrity changes around and across the board. Here's what the rule looked like. This is what they're all flipped out about. This got published after the courts closed on Friday, so the judge had a meltdown. Here's what the order says. Now, of course, Trump issued the executive order, been talking about it for a long time. March 31st, 2026 is when it came down, and been litigating this thing for months now. The executive order says that the federal government has, quote, an unavoidable duty to enforce federal law. We cannot enable crimes to happen in our mail systems. So the order points out the need for additional measures, and that's what we're working on now to reduce the risk of fraud and to protect election integrity. Now, although exempt from the notice and comment rules and requirements, the Postal Service did invite public comment on this, and we're doing everything we can to ensure faithful execution of federal law in connection with federal elections. This rule has an immediate effective date, and delaying that would jeopardize all of this for the 2026 election. Now, they note, right, these are all the lawsuits going on. The one that we just looked at, State of California versus Trump, the League of Women Voters, who are apparently morons because they can't understand a new rule when it goes into effect. They can't even update their websites or their guidance and manuals. We will not take actions to implement this for 2026 until we get relief. That's why we're going to SCOTUS right now. If the government obtains timely relief, implementation immediately thereafter will provide election officials as much time as possible to get their new envelopes created before the mail-in and absentee ballots need to go out. We'll also create a portal that will go into effect, and we've got a bunch of comments that came in. Over 200,000 responses during the comment period, primarily form letters that appear to be drawn from templates. So that's great. So all of the election fraudsters who, gobble up and gather ballots and probably print them out on the pristine ballots and then send them into their fake voter registrations. And that's actually a real thing. You can just go register to vote for basically anybody. We just saw that, I think it was in Massachusetts, where a non-citizen registered another non-citizen to vote because he was mad at him and then referred him for a crime for registering to vote. So a person here on legal status, but not a citizen, was able to get another non-citizen registered, and worse than that, even got the ballot delivered to him and voted in the other guy's name. All of it counted. None of it was rejected by the state. It was an insane story. And if that guy can do it, why can't everybody else do it? Don't even actually need any validation at all. So here, another 200,000 responses. So all of the election fraudsters just fired up the printers and just said, I'll just fill out a bunch of forms. 200,000 of those come in, wild numbers. And other commenters also submitted 250 letters. Bunch of people saying, don't track our ballots. Don't put barcodes on there because we're going to be in big trouble. Now, the red states want this to happen. There was an Alabama-led coalition of 13 state AGs. They said this would actually help us. We could combat voter fraud. We could increase public confidence. It's going to help us. We're trying our best to run clean elections, but we don't have all the resources of the federal government. And so if you implement this, it's going to reduce uncertainty as to whether ballots actually reach their intended destination. Now, many supporters also affirmed that this is constitutional. Many cited the Constitution, Article 2 for the presidency and the executive branch, saying take care that the laws be faithfully executed and that the Postal Service has approval to regulate mail. Congress gave them the ability to do that in U.S. code, seen right here. Now, a bunch of people were unhappy about this, and many of them sued the NAACP, the League of Women Voters. All of them want an injunction. They say, with respect to the substance, they say that the Postal Service will refuse to accept certain ballots. And in the opinion of some, the envelope design could be retained, and other comments were talking about costs and burdens, and it's going to be expensive to add another little logo on the outside of an envelope. A number of others also talked about the Privacy Act, saying now you'll be able to track ballots and see where they're coming from and where they're going, but they did not want that to happen. So many others said this will be, fine, not a lot of comments. And then numerous other comments raise concerns about speculative concerns about demographics, and certain things might be targeted as a result of the rule. So they give us a bunch of conclusions here. They say, in conclusion, Postal Service has considered everything. And the summary here just wants to give you kind of a heads up on what's going on. But we do think we have the authority to do this. Obviously, that's why they're doing it. They run through the legal authority on how they can do this, saying ballots also present unique considerations. And the role has grown in importance. We had COVID. We had the mass expansion of mail-in voting, a lot of that done bypassing state legislatures via settlement agreements between leftist organizations like the Retired Alliance of Michigan and Jocelyn Benson, who then changed the rules because of COVID and emergency. All of this now needs to be reviewed. We got a lot of comments about voter fraud and election integrity. While we acknowledge that there's a range of disagreement on this point, the incidence of voter fraud doesn't impact our rulemaking. This enhanced visibility will then lead us to be able to detect things that have gone undetected. And if there is no voter fraud, then at least we'll have assurance on this. And people like me, who complain about this every day on the show, can shut up, because we can say, oh, great, everything is now being validated. Perfect. Whether or not voter fraud is common or uncommon doesn't really matter. We have the legal authority to take these measures and the rule to facilitate this to reduce the risk of fraud, and that's what we're going to do. Now, they also say this is going to supplant the state's ability to administer elections. That is fundamentally erroneous. We are not turning the Postal Service into an election administrator. We're not dictating the manner of elections at all. On the contrary, it's not that at all. It's using a mail piece design and simple data reporting standards that we already use in mail. States maintain complete control over their voter list, decides who is eligible to vote. They retain complete autonomy on how and whether they use the Postal Service. Nobody's forcing them to use this. They can use UPS. Some commenters also acknowledge the Postal Service's authority to impose general standards, including ballot mail. Election day mail must conform to other rules, and we're not constitutionally obliged as the USPS to defer to some given state's outbound design preferences. They don't want to use barcodes. That's their problem. On the contrary, establishing a standardized set of mail piece design requirements, all being tailored to this process, includes and increases visibility. It's not election administration. It doesn't usurp state resources at all. All it does is help us validate fraud. Similarly, nothing is dispossessing the state. Eligible voters will still be able to vote, and the rule doesn't involve even the inspection of the ballot's contents. It's just on the outside. All we're putting on there is a barcode scan. And so accordingly, we're allowed to do this. Any other concerns about privacy rights and other things are misguided. Though some commenters correctly acknowledge that the Postal Service does not propose to disclose voting choices, other commenters say that it would compel the creation and maintenance of records identifying citizens who do the mail-in or absentee voting. Now, these amendment concerns, though, are misplaced. First of all, the Postal Service reiterates it's not going to collect or record any party affiliation. We're not going to inspect the ballot contents. Postal Service personnel are not authorized to open these things. All they're doing is maintaining the data that is routinely generated for mail from the exterior of the mail piece, including addressing and barcode info. Doesn't require any collection of political parties, and all we're doing is tracking the barcodes. Now, they could invoke it if we were looking at the contents, but we're not. There's also Fourth Amendment concerns, unreasonable search of people's votes, due process concerns, saying our rule doesn't determine eligibility to vote. You can vote if you want. All we're doing is checking the outside of the ballot. So lots of details in this rule. It goes on for 95 pages, but they're articulating why they have the basis to do it. They have a lot of authority under U.S. Code, saying that here, multiple commenters also contested the fact that we can do this. They say that criminal laws have nothing to do with voting and they're not enforceable by the Postal Service. They articulate all of their arguments, and it goes on and on and on. Now, let's see if we get a conclusion down here. It goes on for 95 pages, but we are consistent with all of this. We disagree with their assessments that we're not following the rules. Section 101A of Title 39 establishes that we can do this. In fact, we have a legal mandate to do this, to provide mail services, data reporting, and more. walking us through all the laws that they can invoke in order to get this done. So lots of details here, but this is what they're so upset about. And at the tail end of this, it goes on for 95 pages. Just want to show you kind of what's going on here, how it's going to work. And they're clarifying a bunch of things. And so we get the gist of it. But we now agree there's going to be training that's necessary and other state law concerns. It's all going to be just fine. So stop your crying about it. But while this is going on, we also know that the red states are appealing. So this one came out of the District of Columbia, again, with the League of Women Voters. And Texas has also filed a notice of appeal. So the lower level judge blocked it. Now Texas hereby appeals to the Court of Appeals in the District of Columbia, saying we actually want this to go into effect, signed courtesy of Ken Paxton's office and Brianna Crow-Minga. So we're knocking on the door of the Supreme Court. The red states are also demanding an appeal. And while all this is happening, we see that actual election integrity is a popular thing. This is a new segment here from even CNN that's saying, everybody wants it. Nationwide voter ID. We want to have real elections that are not being perverted by dead people, by people who've moved out of state, by people getting multiple ballots. We don't want a free-for-all. It's our birthright to be able to self-govern, and you can't do that at all if the elections are completely twisted. Here is Harry Enton over on CNN.
Take a look here. Favorite photo ID to vote. 85% of white people favor it. 82% of Latino. 76% of Black Americans favor it. So the bottom line is this. Voter ID is not controversial in this country. A photo ID to vote is not controversial in this country. It is not controversial by party, and it is not controversial by race. The vast majority of Americans agree with Nicki Minaj that, in fact, you should have a photo ID to be able to vote.
So something of a non.
Take a look.
Yeah, so Kamala Harris blown out. She says certain ethnicities and groups of people just don't have IDs. They can't get IDs. You need an ID for virtually everything in America except for voting. In fact, in some locations, you can just go vouch for other voters, like in Minnesota. Just bring in whomever you want, and they all get a ballot without checking who they are at all. In other states and locations, you can literally register other people to vote. You can get their ballots and vote for them. And that guy probably wouldn't have been caught if he hadn't also reported the person he was voting for to the authorities to get that person arrested and then deported. So how much more is that happening across the country? We don't really know. They say it's not happening, but they can't possibly know that because they don't check at all. And they do limited hangouts where they say, oh, we just checked for 1 year. From June 23 to June 24, we found 6,600 people on there, 400 of whom voted. Was there any more? No, it was just a glitch. Not our fault. And then it's happening over and over again. So now we're going back up to the Supreme Court. We got elections coming up soon, and we need to get some clarity on this. These are very, very simple routine changes. All we're doing is just tracking mail, just like certified mail. Where's it coming from? Where is it going? They don't even want that to happen. So we'll see if this little piecemeal approach works. They've watered down the order from Trump's executive order to get that through. And then once that's through, presumably, they'll start adding on some toppings to this delicious election pizza. We're going to keep our eye on this one and all of the election litigation going on right now as the midterms approach. It's going to get hot. Thank you for joining us as we do. Now, let's talk about Ilhan Omar because she's also in big trouble right now. Ilhan Omar in big trouble, officially now being investigated for criminal prosecution. That's according to Just the News. And it's official by implication because what we saw is there was a FOIA request for certain records, and those records could not be delivered because an ongoing pending investigation is occurring. Now, in addition to that, Ilhan revealed to us in a letter that she sent over to Homeland Security that there was apparently an undercover investigator, some other agent from HSI, who was monitoring her at one of her events, and she's very unhappy about that. So two pieces of the puzzle now come into play, and we're starting to learn more about what's going on. And the president really raised some eyebrows this weekend when he shared this post from Just the News saying ICE now refuses to disclose records on Ilhan Omar's fraud probe, cites ongoing enforcement proceedings. Dun, dun, dun. And the story comes from Just the News. They submitted a FOIA request. Now, fraud presumably is criminal fraud, and we'll take a look and see exactly what they requested. But the government is now refusing to turn over records that are related to an ICE investigation, saying there may have been immigration fraud from Ilhan marrying her brother. We got the document that they sent back to Just the News. They filed a FOIA request back in January. We just got the response. They said, we can't give it to you. Seeking records that are pertaining to these investigations into allegations that she married a relative in order to help him remain in the country. And now it's certainly looking like there's a there. Now, Omar has denied the allegations. No court records, no DNA evidence, no other documentary proof has ever substantiated this, saying that Ahmed Nur Saeed Elmi, Omar's legal husband from 2009 to 2017, was her biological brother. Gross. ICE responded. We'll take a look at the document. And the reply gives us some details. Here's what it looks like, courtesy of Just the News. They respond over to John Solomon. He's the purveyor over there. It says, "Hi, dear requester. This letter is the final response to your FOIA request to ICE that you sent back in January. You have requested records pertaining to an investigation conducted by ICE about allegations of immigration fraud involving a member of Congress marrying a relative from 2016 to 2021. Now, ICE has determined that the information you're being requested here is being withheld pursuant to U.S. Code. Disclosure of any responsive records at this time could reasonably be expected to interfere with enforcement proceedings." You can't get them because we need them right now. FOIA Exemption 7A applies to records or information compiled for law enforcement purposes when their release could disrupt such proceedings. Oh no, for Ilhan. So please note that even if Exemption 7A were no longer to apply, other FOIA exemptions listed here, 6, 7C, 7D, and E, may still protect certain information. Now, you have a right to appeal this if you want to. Send your appeal over here within 90 days. You may submit your appeal through the secure release portal. Otherwise, we're done. There's nothing more that we can do on this because we need those files in order to potentially prosecute her. So there's more from them. We can read the letter below. And if you want to invoke the exemption 7A, two-step analysis needs to be implicated. First, there must be a reasonable likelihood of a pending or contemplated law enforcement proceeding. The guidance says, if you look back at the guidelines for the redactions. So reasonable likelihood, nice. And second, release of the information must be reasonably expected to cause some articulable harm to that proceeding. So if she's about to get charged or about to be indicted, and you release the records, hi, this is all the evidence that we've got. These two, were seen in one of those love hotel rooms after their wedding or whatever. Then that might give Ilhan and her brother notice that this is happening, and then they may be able to destroy necessary evidence or flee the country back to Somalia. Harm includes things like exposing the case to witness tampering, tipping off the suspects. The exemption makes no distinction between criminal, civil, or administrative cases, but presumably immigration fraud would be charged as a crime. They reached out to Omar's office. She did not respond to a request for comment. Some people say this is known. This is obvious. It's been an open secret. Everyone knew she married her brother going all the way back to 2016. In fact, Tom Homan said last year in December that the DHS was investigating Omar, whether she married her brother. He said, we're pulling the records. We're pulling the files. We're looking at it. I'm running that down this week. And J.D. Vance also confirmed it as well. He said, I don't want to prejudge an investigation. It certainly seems like something fishy is there. Ugh. If we think that there's a crime, we're going to prosecute that. And that's something the DOJ is looking at now. Now, the allegation that Omar's second husband, Elmi, Ahmed Nur Saeed Elmi, is related first surfaced back during 2016 when she was running for Little Somalia. At the same time, allegations emerged that when she married her second husband, she was also still married to the first. Now, Omar vehemently denies this, saying this is categorically ridiculous and false, but the timeline is not in dispute. Omar was born in Somalia, lived in a refugee camp in Kenya, came here in 1995. Then in 2002, Ilhan applied for a marriage license to marry Ahmed Hersi, but did not marry him civilly, only in a Muslim ceremony. Then in 2008, she separated, and a year later married this other dude, Elmi, the bro. In 2011, Omar and Elmi separated with a Muslim divorce, and a year later, she began her relationship with Hersi. So hard to keep track of all her marriages. After her election to Minnesota House, she then filed for a divorce from Elmy, and she married Hersey in 2018. Trump has said repeatedly, she married her brother. Everyone knows it. In order to get him into the country. He said she married her brother in order to get in, right? She married her brother. Could you imagine if Donald Trump married his sister? He also called for her removal, saying we ought to get her the hell out in a December 2025 rally, which may be a case for denaturalization if you commit broad immigration fraud or lie on your N-400 form, as she may have. So in addition to all of that, we have more validation even from her that she is actively being investigated. She sent this back in early August to the interim special agent in charge out in Minnesota. Guy's name is Special Agent McCarthy. So this is signed by Ilhan Omar. You can almost hear the panic in her voice. She says, "Hi, Special Agent. Thank you for meeting me and Pramila Jayapal, the other one. We appreciated the opportunity to present the priorities of Homeland and raise concerns about Metro Surge, which was the insurgency against ICE that really hasn't been dealt with. Yesterday evening," Ilhan says, "in August, I hosted my monthly town hall in Richfield, Minnesota. Now, due to the volume of threats that I receive, we take active precautions. My team and I all take a look. One of those precautions is working with local law enforcement to prevent potential attacks like that guy who sprayed her with that apple cider or whatever that was. As attendees were entering the building, I understand that a Richfield police officer noticed a young woman sitting in a Ford Explorer, and he became suspicious of the way that she was monitoring the building. He proceeded to run the plates attached to the vehicle and discovered that they were registered to a different vehicle. So this guy, this local officer, approaches the woman in the vehicle to ask about the purpose. Hi, ma'am, why are you here? Why do the plates on your vehicle not match the government's records? And like any reasonable officer, she says, he was concerned that she harbored ill intentions and may be in a stolen vehicle. Now, I understand that she initially identified herself as security, and after the police confirmed with my security that she was not a part of our operation, she called her supervisor and explained that she was an HSI agent who was tailing and monitoring the brother lover, saying that she was outside the community center as part of an undercover drug operation in the area. Yeah. A prominent sign indicating that my town hall was taking place was visible, and that did not result in any reconsideration of whether that agent there was being appropriate or necessary. And so after speaking with her supervisor, she then left. So she got identified, HSI person, and then bails. Now, at a March meeting with HSI, I raised dozens of reports that we've received from community members about HSI switching plates on vehicles because they're all being tracked in Minnesota. Anything that looks like a government vehicle, any body is being tagged. They have Airtable, spreadsheets where they're watching these people and deploying interference agents to go and prevent them from doing their jobs. So now this is illegal. It appears that this commitment is untrue. So their actions yesterday put an entire community at risk. Instead of monitoring the area for those who wish to harm me, police were required to devote time to this HSI agent who was monitoring a congressional event with mismatched plates. It also raises serious concerns and uncomfortable questions about why Homeland is there. We all know why. At your best, your agent was unable to assess the parking lot of a community center. This wasn't a drug operation. And at worst, it emphasizes many Americans' concerns that ICE is surveilling political opponents or just potential immigration fraudsters like Ilhan Omar. She is apparently immune. She is, in fact, according to her, above the law, and no actual investigation can take place. So I request your prompt attention to this. She's very upset. Please explain why this agent was there. Please explain when and how this agent and her supervisors became aware I was hosting this. I want an overview of the training that she got. How long has she been an agent? Richfield police got no advance notice of this. And what are they doing combating drug trafficking? Well, there's a lot of Somali fraud. Maybe they're also trafficking drugs. Please explain what you want to do and how you're going to coordinate undercover operations in the future. And please share any details of any meetings or other events I have hosted where agents were there. So I'm very mad that you did this on this time. But can you please also, I'm a member of Congress now, can you please tell me all of your other surveillance techniques and avenues that you have been monitoring me for, please? Because I'm freaked out. You may have seen me actually trafficking in something. Please share whether other agents have observed any activity being undertaken in an official capacity anywhere else by any other local, state, or federal officials in Minnesota? No, it's an ongoing investigation. You're not entitled to that information. It's the same Christopher Wray objection. Sources and methods, ongoing investigations. We're not going to be doing any of that. So that's signed by Ilhan Omar, all making its way over to the special agent. Don't know if she's gotten a response to that, but hopefully the investigations continue. Now, Stephen Miller was explaining this, saying what we're seeing here is pure tribalism from Ilhan and her Somali constituency. We've got these various groups of people who come into America. They create these enclaves. They have no desire to assimilate at all. Many times they'll say, we are assimilating, as though that's a good thing. But then by the same token, they'll turn around and say, we want diversity. We want ethnicity. We don't need to assimilate. And of course, they're not. So here's Stephen Miller explaining what's going on with Ilhan and the rest of them.
Who are they trying to redistribute from and to whom? The fundamental mistake that Republicans and conservatives make when talking about and dealing with socialists is assuming that we're having a rational, good faith conversation about the distribution of assets in this country. In other words, there's a group of people who all love America, who love Americans, who love the people who built this country, who love the middle class, and we're having a rational, good faith conversation about who should get what in this country and in what amount. You know that famous expression, right? A rising tide lifts all boats. Having that conversation assumes that you are talking to somebody who cares about everybody's boat equally. When you think about, for example, the Somali refugees in Minnesota and Ilhan Omar, that's not the heuristic that they're using to talk about prosperity. They're thinking about it as the people who built this country, Western civilization, the generations that have been here, that blazed the trails, that won the wars. We are taking from them to give to ourselves and our progeny. It is a purely tribalistic redistribution. So in other words, the foundation of DSA, of the modern Democrat Party, of Democrat socialism, Marxism, in all of its forms. In other words, what unites the jihadists, the Islamists, the open borders crowds, the Democrat socialists, the radical leftists, what unites them all is saying that you American, you who built this country, you who sweat and toil and sacrifice created this country, you who sublimated your own desires so that your children and their children could have something better, you don't deserve to have security anymore.
That's exactly right. And so Stephen Miller hammering the point home. As we can see, we've got very problematic actors in America. Ilhan Omar is one of them. We saw the entire state flip even their flag to look more like the Somalians. They were enabling fraud. Tim Walz knew about it. It was going into the budget. Keith Ellison was protecting the fraudsters. And now we've got marriage fraud that is presumably being investigated. And we know that because of the FOIA. By implication, they're not going to release the records. There's an ongoing investigation, so you can't see it. Ilhan also freaking out that undercover HSI agents are there doing drug investigations outside of her events. And so we're going to keep our eye on this one. Maybe we'll get some indictments very soon. All right. And now, my friends, we got some breaking news here. Thank you to the chat for flagging this for me. MCM, major Supreme Court ruling just dropped. And so we're going to deviate a little bit here. And I think I was able to get a quick summary of this, but SCOTUS just dropped this, and it looks like a victory. And let's get into this one. Ooh, boy, do we love stuff fresh out of the oven. Oh, baby, it's good. All right, and let me just get my bearings straight on this. I think it's going to be a big win across the board. Let's get into it. Make sure our red pen is working, and it is right here. Major victory out of the Supreme Court of the United States relating to the election injunctions that have been handed down by lower level judges. We know that the president issued an executive order saying we're going to fix certain parts of the mechanics of how we actually count and collect the votes. And a bunch of the blue states ended up suing the president to say, we love our rigged elections. We don't want to change anything at all about it. This has been working its way up to the Supreme Court for quite some time. We've talked about Indira Talwani. We've talked about Sparkle Suknanan. We've talked about the NAACP, League of Women Voters, and more. And now we've got a decision. The court is now ruling on an application for a stay from the Trump administration. Lower level judges blocked the implementation of the order. Trump asked to stay the block so that these can go into effect. And here it has been handed down. In a per curiam opinion, the decision of the court, they write the following. The President Trump recently issued an executive order about election integrity, and then a group of states sued. The blue states sued in Massachusetts in Indira's courtroom, contending that the order unconstitutionally infringes on their authority to administer elections. Now, the district court agreed and enjoined the government, blocked Trump from doing it. And in doing so, Indira Talwani, the Obama judge, and the others rejected the government's argument that it lacked jurisdiction over the states' claims because the states lacked standing, saying, I can block them, you can sue. The government has asked us to stay the injunction, saying that they are going to win on the merits on the jurisdictional argument that the injunction itself is causing irreparable harm because the Postal Service can't do their work. The administration, Social Security, Homeland, and more working on the citizenship list can't do their work, and that the equities do not favor leaving the injunction in place while the government's appeal is pending. And so we agree and grant the stay. Victory for America. Here's more from SCOTUS. They explain about 5 months ago, President Trump issued an executive order designed to maintain public confidence in federal elections. That's right. The order is an internal directive from the president inside the executive branch to his subordinates, mandating that certain agencies pursue certain policies. It neither requires nor forbids anything outside of the executive branch. Trump's the president. He's only making management decisions inside his agency, his branch. 3 sections of the order are relevant here. First, we saw Section 2A, that's the citizenship list component, saying that Homeland will, quote, take appropriate action to create a citizenship list. These lists will catalog the residents of each state who are citizens who are above the age of 18 at the next election. States are not required to use the lists, and the secretary may compile and transmit them only in a manner that is applicable with the law and consistent with the rules. Then we have another section, 2B. They were very upset about this because it said the AG is supposed, the Attorney General will be prioritizing the prosecution of other officials, even local or state election officials, who issue federal ballots to ineligible voters, saying if you hand out illegal ballots to illegal voters, you're responsible for that. You can no longer hide behind, I didn't know, or it was a glitch, or this is taking over my privacy rights or whatever. You have an obligation to secure the elections, and if you don't, we're going to prosecute you. Third, Section 3B also goes to the Postal Service to initiate rulemaking, saying that one provision is that outbound ballot envelopes must contain a unique barcode to track them. The order does not demand that any proposed provision appears in the rule, and that's it. Now, all provisions of the order have to follow the law. It's literally in there, must be implemented consistent with applicable law. So a few days after the order was issued, a group of states and DC filed a lawsuit in Massachusetts. The Blues went to Indira Talwani and sued. Now, as relevant here, the state said that the sections are unconstitutional. They wanted to block it. The government said, you can't even sue. First of all, the order doesn't injure you at all. So there's no harm. So you have no basis to settle a claim in controversy and to get the court to fix something because nothing is broken. The district court, Indira Talwani, the Obama judge, largely agreed with the blue states and entered a final judgment saying the Trump admin cannot implement any of these things in the midterms. After the First Circuit denied the government's request for a stay, so the block continues, the government then, Trump, went up to the Supreme Court and said, please help us, we need assistance. Now, to secure a stay pending appeal, the government must show that it's going to win on the merits and that it will suffer harm if the implementation is not allowed. It must also demonstrate that if you balance the equities, that doesn't counsel against relief. And so of these factors, the likelihood of success and the likelihood of irreparable harm are the most critical. So the court will analyze according to those standards. Saying, as to the first factor, The government is likely to prevail on the merits. Let's go. That the district court lacked jurisdiction to enter the judgment. Two related doctrines of justiciability block the state's lawsuit. One is standing. We saw a lot of this in other election litigation in 2020. It requires an actual injury. It cannot be just conjecture or hypothetical. The other one is ripeness. It forbids federal courts to adjudicate disputes that are not dependent on contingent, speculative future events that may not even occur. Now, because standing is not dispensed in gross, we address each of the provisions of the challenged order separately. Section 2A, as we know, directs Homeland to create a citizenship list. The Supreme Court just decided this. This provision is an internal directive from the president to a subordinate. That's it. There is no obligation to the states. They suffer no concrete harm at all. And without a concrete harm that is being delivered to them, there is no standing. Get out. So the true source of any injury to the states might be downstream of the action that the secretary might take. Emphasis on might, says SCOTUS. Section 2A can be implemented only according to law. It's in the order. If they break the law, then they're violating their own order because the order says follow the law. So, and as the court explained in another case involving presidential directive with a similar qualifier, any prediction how the executive branch might eventually implement this while balancing feasibility and lawfulness is no more than conjecture at this time. In Trump versus New York, that went up to SCOTUS as well. So the secretary's eventual action will reflect both legal and practical constraints, making any prediction about a future injury just that, a prediction. So you're complaining about something that hasn't happened. So there's no harm and you can't sue. So to see why, consider this. The unduly, quote, long chain of inferences that are necessary to support the blue state's concrete injury. Here's what they have to pull up, saying the district court first had to speculate about whether it would be, quote, feasible for the secretary to create and transmit the list before the midterm, saying, I don't even know if they can do that. Well, it's not your job. You're not in Homeland. So why are you even deliberating on that? But Section 2A may not prove feasible to implement in any manner whatsoever. So the court then had to guess how the secretary might tailor this to be consistent with the law. So she's saying, I don't even know if you can do it, but if you can, then you're going to have to do it this way. Next, the lower court, Indira, had to predict what action the secretary would deem appropriate for implementing this. A third, speculation and inference. And after all that, the court still had to estimate whether those actions would be taken in a way that would substantially cause harm. But Article 3 says you can't do that. No standing from stacking hypothetical on hypothetical to speculate that harm may or will eventually materialize. Adjudicating this claim requires a prediction not only about whether the secretary will act before the midterms, they may not even do it, but also about the shape that any action may ultimately take. And Article 3 demands more than that. Actual cases and controversies. You have to have an actual harm. The lower court, Indira, though, from Obama, saw it differently, concluding that the states suffered, in fact, a present injury because it required them to, quote, begin planning now on how to comply with it. It hasn't even been implemented, but they have to start thinking about it. And thinking is very hard work for them. So the states, though, cannot manufacture standing by merely inflicting harm on themselves based on the fears of hypothetical future harm that is certainly not impending. You want to spin yourself into a tizzy over this and over-engineer possible outcomes and make a decision tree? Well, what if they do this, then that, and what if they... That's all on you. It's not actually real yet. And the hypothetical future harm that the states fear, which would be the implementation of this, is far from, quote, certainly impending. By allowing the states to bring this action based on costs that they incurred in the response to a speculative threat, this was improperly watering down the fundamental requirements of Article 3 standing, and they lose. Now, perhaps recognizing the weakness of that standing rationale, the Supreme Court writes, the Court of Appeals added another. They said, well, it's not just the speculative planning harm, it's also that 2A, the list, infringes on states' sovereign authority to create election rules. All made up. But 2A doesn't do that at all. It does no such thing. Instead, all it does is simply directs the secretary to make certain actions, if appropriate, feasible, and lawful. This is an internal directive inside the federal government. It doesn't regulate the state's voter registration processes at all, nor does it impinge on the state's authority to create and enforce a legal code. All they're doing is making a list internally. They're the federal government. They're allowed to do that. The fact that they're doing it doesn't hurt you states at all. Now, similarly, the states also lack standing to challenge Section 2B for much the same reason. It doesn't do anything to them. This provision directs the AG to prioritize investigations and prosecutions of those who violate already existing federal laws. It's already illegal to give ballots to ineligible voters. The fact that they're prioritizing it doesn't change anything. Setting prosecutorial priorities lies within the president's Article 2 powers, and his decision to prioritize those prosecutions of certain offenses doesn't inflict on any other traditionally recognized harms on the states. Everyone does that. All presidents come in and say, we want to focus on this and less on that. Biden came in and said, now we're getting the white supremacists and the pro-lifers and the religious school parents and more. Now Trump is saying we're just going to prioritize election fraud. It's already illegal. And if you're a secretary or a clerk or anybody in the government who ultimately facilitates that, you're liable. So if the states try to avoid this very straightforward analysis by misreading the order, they say that Section 2B threatens them with prosecutions if they don't use the citizenship lists. Even Sotomayor is crying about that in the dissent, along with Ketanji. But that view is inconsistent with what the order actually says. The states concede that Section 2A does not require them to use the list at all, even if they get one in the first place. Like, we don't even know if they're going to get a list, but they don't have to use them. Now, opposition to application, they cite the opposition. So it is logically impossible for a state to violate Section 2A, and Section 2B doesn't suggest otherwise, because they don't have to have the list. Section 2B also directs the AG to, quote, prioritize prosecutions if there's a violation of federal laws. It then provides already existing statutes for the AG to enforce. They're not making up new crimes. It's already illegal. Now, absent is any reference to the citizenship list. They're not saying if you don't use the list, we're going to prosecute you. All they're saying is this list is available. The list will serve as a nice tool that you can use if you want to ferret out voter fraud. But if you don't want to do that, don't use it. That's fine. But if you do commit voter fraud, then we're going to come after you. If you're facilitating the delivery of ballots to people who shouldn't get them, you're responsible for that. Don't have to use this tool, but you still can't do that thing. Use another tool. Make your own list. Do your own checks. Fix all your glitches in New Jersey, whatever you need to do. But just don't give people who don't deserve ballots, obviously. So without a textual basis for their concerns, they're referencing the order. The order says nothing about that, saying that they're going to be prosecuted. That is not a well-founded fear. They lack it. Now, they also reference other state laws allowing 17-year-olds to vote in primary elections, saying that is a red herring. Now, because Section 2B defines eligible voters and otherwise qualified citizens who are 18 years of age or older, the states say, well, we could be prosecuted if we give ballots to 17-year-olds during primaries. And so if we do that, we may be charged by the DOJ for committing voter fraud. But they say not so. That's ridiculous. Section 7B of the actual order, if you read it, requires Section 2B to be implemented consistent with applicable law. And if you vote in a primary at 17 and you're going to be ultimately 18 at the time of the general, we'll allow you to do it. Primaries are, largely governed for and by the parties in order to select the candidates who will ultimately go into office after a general. So given these provisions, the government has unsurprisingly disavowed any intention to prosecute 17-year-olds who get primary ballots. That's not part of this, because that's would be inconsistent with applicable law, and they're going to be consistent. Now, lastly, we've got the states challenging Section 3, which here applies to the Postal Service. So according to the states, again, the internal directive from Trump, from the president to his agencies, demands that they overhaul their existing election procedures. They say that our state procedures are going to be taken over. Supreme Court says it does not. Section 3 orders the Postal Service, not the states, to initiate the process for proposing a rule that might bind the states in the future. It does not, and it is not a proposed rule, let alone a final rule, and it imposes no legal requirements on the states at all, or for that matter, on anyone outside the executive branch. It's internal. So the lower court's conclusion that this internal directive inflicts an Article 3 injury on the states rests on, again, an attenuated chain of inferences. You have to make it all up in order to reach the harm that justifies your actual remedy, which is the blocking of the order. So at this time, at the time the suit was filed, the time when standing is measured, we look to that. The district court had to engage in a string of speculations to find this suit justiciable. It first had to speculate about whether the Postal Service would even propose a rule. Then it had to speculate about how the agency would weigh the comments that it received. Then it had to speculate about whether the agency would even issue a final rule, all on top of one another. Then, in addition, it had to speculate about what the final rule would say. And then finally, after all that, the lower court also still had to speculate about whether the text of a hypothetical final rule would even harm the states. It's like 5 of them now. So it should go without saying, says the majority of the Supreme Court, that the lower court made a decision dependent on contingent future events that may not occur as anticipated or indeed may not occur at all hypothetical. So therefore, the states cannot preemptively concretize their injury, manufacture the injury by then expending funds before the Postal Service finalizes a rule. Well, we have to research this and it's going to come out of our budget. We have to figure out what it's going to cost and hire people and all these things. That's your choice. Nobody's ordering you to do that. Spending money to hedge against a speculative threat is not an Article 3 injury. Otherwise, people would do that. People would just go say, oh, I don't like this governmental rule. I have to go spend a bunch of money because something may happen that may be bad for me, and therefore I have standing, and everybody would sue. Nope, can't do it. Got to be an actual concrete injury. Though it may sometimes be a reasonable reaction to incur certain costs in advance of a rule, those costs cannot establish standing when the final rule remains a hypothetical future harm that is not certainly impending. Federal courts review final rules, not proposed rules, and certainly not antecedent internal directives to propose a rule. So if the Postal Service's final rule actually does harm the states, then they can challenge that rule. And so the remaining factors also favor relief here. The government is likely instead to be the one to suffer the harm without a stay. The lower court's breach of Article 3 interferes with the internal operations of the executive branch. That's right, Indira Talwani. That's right, Sparkle Suknanan from Trinidad and Tobago. The injunction bars Homeland Security from even trying to compile citizenship lists for about half the states in the union, all blocked by some district judge. It purports to forbid the AG to implement the president's enforcement priorities as to those same states as well. And it prevents the Postal Service from so much as initiating a rulemaking that could yield a rule that applies to those states. So because reversal of the lower court's judgment would come too late for the 2026 midterms, the district court's errors deal a serious setback to the executive branch and their goals while all of this litigation is unfolding. And when a federal court improperly intrudes on a coordinate branch in this way, this interim relief is justified. And they're referencing the Trump versus Casa case, which again was the limitation of nationwide injunctions. They were saying, well, there's a bunch of illegal aliens all across the country. And so I'm going to block this group of plaintiffs, but apply it to everybody in this class. So fighting this court's precedent, Ketanji about to get blown out here, Justice Jackson maintains that the government is not injured in the slightest. Yeah. Because the order contemplates the government will engage in patently unlawful conduct, quoting her. So that, however, remains to be seen there, Ketanji. And though Jackson wishes it were otherwise, an applicant can show irreparable harm from a threshold error without also showing that, at the end of the day, it will prevail on the underlying merits. So such harm exists here because the injunction meddles in the workings of the executive branch, preventing it from even trying to lawfully implement the order. They can't even do it legally. And we can't tell whether they've done it legally or not. They're just prohibited at the outset because of these hack judges. So finally, the balance of the equities does not counsel against awarding the government interim relief, is the quote. And that's a quote from Casa. The executive order makes no demand of the states at all, so staying the injunction from Indira will not concretely harm them at all. That is why this suit was not justiciable in the first place, and the lawsuit shouldn't have even advanced at all. Now, they give us a footnote here about the dissent. The principal dissent says that if the order does not legally bind the states, then the government cannot suffer irreparable harm from the injunction. But the dissent reasons that this is so because the injunction merely prohibits prosecutions stemming from violations that are unconstitutional in the order. And if it is impossible to violate the order, then the injunction targets a null set of conduct. In other words, if the states don't have to comply with the order, then they can't be prosecuted for that order. And so the government is not harmed by blocking them from stopping prosecutions against people who are in that bucket. So the government suffers no harm at all. So then Ketanji would put it on the equity balancing test and say there is no harm. But the injunction is far broader than that and what Ketanji is trying to articulate. It declares that all of Section 2 ultra virus outside of the law as to the states. It blocks the government from giving any effect to Section 2 as to the states, which is the citizenship list, and requires the government to prevent explicit or implicit implementation as to the states. It is the breadth of these provisions and the resulting intrusion that is the irreparable harm because they can't even contemplate these changes. So the court's disposition of this application does not mean that any measure taken by the government to implement the order will necessarily be lawful. We could come back on this once these things are implemented, once there is a harm, if they can articulate that and show that, then we'll come back here and maybe we'll rule differently. Now, on that score, time will tell, but the order itself does not harm the states, so the lower court lacked jurisdiction to bar the government from trying to implement it. Blown out, baby. And for the reasons discussed, that injunction is likely to irreparably harm the government if it remains in place while the appellate process runs its course. And so, accordingly, the application for a stay that is presented to Ketanji and by her referred to the court is hereby granted. And Indira is a loser. The injunction entered by the district court in the District of Massachusetts is hereby stayed pending the disposition of appeal in the Court of Appeals and pending disposition of a petition for a writ of certiorari in the court if that is timely sought. If we deny that, if we don't want to hear the case, if we say the Court of Appeals is valid and has handled this appropriately, then we'll just terminate the stay. But if the Court of Appeals does something dumb again, and they will, and the cert is granted, then the stay shall terminate after we get the new petition and then send that back down with the judgment of this court. And so the application for a stay presented in another case and by her referred to the court is denied as moot in 26A 139. And so that is a big win. And I am sure Mark Elias and all of the leftist lawfare hacks are very upset about this right now. Let's take a look and see if I can just do a quick check. This is all coming fresh out of the oven right now. What that other case is, 26A 139, and do a quick search for this on the Supreme Court and find this case because that may be another one of the cases that we are covering here, which is moot. So this will largely apply to that as well. And that one is, yeah, that's Alabama. Okay, so it's the same case. It's just another petition. We got 26A 124 and 26A 139. Alabama submitted one and the DOJ submitted one in kind of two separate matters. But so that goes across the board. And this is very interesting. So it's not going to, this is only on one case essentially. Let's just go back up. We've got other matters that are out there. So this is Trump versus the states. Now there's other ones. There's the League of Women Voters that we talked about in another matter, which was not that one, this one. So we also have Texas, which is appealing the League of Women Voters. This one's coming out of the District of Columbia. But it's going to be the same, I think, standing principles, even for the League of Women Voters, okay? Even for the NAACP. All these groups are suing. And if the states don't have a harm, and the states are actually governing the elections. The state's harm, as we just saw, was all about, well, we have to change things, and it's going to be difficult for us to do that. That is even less significant for these third parties. The League of Women Voters, their main claim was their members in the women voter group, Spice Girls, are all going to be now having to expend energy, expend resources. They're going to be confused. It's going to be difficult for them to update their websites, update their guidance, and train all their members. So their standing, I think, is even lower than the state's standing. And so presumably this will also spread around to the other cases in the other courts, including in this one, to say you're just now speculating about what's actually going to happen. You haven't shown what the harm is actually going to be. And so therefore your case is also not legitimate. You don't have standing. It's not ripe, and your case is going to have to be stayed. So that is a tremendous win. I think it's going to spread around like wildfire to those other cases. And it's very good news, which is why you can see why Sotomayor and Kagan are so mad about this. Yep, here's what they're saying. We'll just do a quick look at this. And saying all of this is about Trump's attempts to interfere with the states. And so Sotomayor is saying this is going to be her respectful dissent. And it doesn't say that the executive branch has any right to interfere. And we've read the order. The whole thing is ridiculous. So she's mad, saying a simple read of the order is that it will lead to enforcement. The states can essentially read the order and, articulate what the next steps will be, saying the government doesn't actually suffer any irreparable harm at all, walks through the same sections of the order. And because I believe the structure of the order and the government's representations and the equities counsel against emergency relief requiring the states to wait, I respectfully dissent. That is from Sotomayor, joined by Kagan. And then Ketanji, gosh, she talks so much. She goes on, we're on page 15. She goes on for the remainder 37 pages. And this mirrors her verbosity in the oral arguments, saying Trump issued an executive order demanding changes. And this ruling violates precedent. And it lets another shoe drop in the Kafkaesque nightmare. All right, from Ketanji. What are you talking about? That we've been cheating certain plaintiffs who bring election-related challenges? That's hilarious. Do you know how many election lawsuits we covered in 2020 that were all nuked based on standing? Ketanji. So she just keeps going and going and going. She says it's a blatantly unconstitutional order. So I respectfully dissent. States administering elections and the voting public that relies on them deserve clarity, not caginess or confusion. Well, that's the whole point, Ketanji. You need an actual rule in order to challenge. You don't just get to say, I'm scared about something that might happen. Clarity comes from finality. Once it's decided, then you can sue and cry about it. And they will, by the way. So now she says this contributes to pre-election chaos. Yeah. No, you know what? We could have done all of this a long time ago, back in March when the order was actually entered. And you guys sued into oblivion to try to drive it closer and closer to an election. You're causing the chaos. And she's very mad about it. So again, Congress, the Constitution delegates power to run federal elections to the states, as we just saw. I don't know who wrote that majority. Maybe it was Alito. Sounded a little bit Alito alien to me. But she's going to go through and, it goes on for 37 pages or for another 15 pages. And again, nobody's arguing this, Ketanji. Yes, we know power goes to the states. Nobody is taking that away from them. Thank you for setting the Constitution for us. Hopefully you actually read it. And she's going to do her thing. Let's see if there's any other, major sections in here. So needless harm on the plaintiff states. Again, there's no harm to them. It's not even finalized. So it's a good win. It's a really good win when Ketanji just keeps writing all of this out, just like spitting it out with ChatGPT or whatever. And there is a proposed rule. And the court took language from other precedents. This is how you know it's bad, because it's just so long. It's very Ketanji. Let's see how she ends it. Sometimes we'll read these because sometimes she'll say ... wait for it ... or she'll talk like she's writing a blog post on a Substack. But she says, in any event, this court should not have gone out of its way to correct the lower court's purported misapplication, especially given the government's abject failure to defend the executive branch and their underlying legal authority, and all that is at stake in the disputes over last-minute changes. Okay, so we got it. So it's just too close to the election, so things are going to be changed, and it's going to be a big problem for the states. When the government's goal is to interfere with their practices and prerogatives in a manner that the Constitution doesn't authorize, again, it's not interfering with them at all. They don't have to use mail-in ballots. They don't have to use the Postal Service if they don't want to. Require in-person voting, but the Postal Service is under the federal stewardship of the executive branch. And so it is both a serious legal error and a grave misuse of our equitable emergency powers, so more, shadow docket nonsense, to proceed even one step further. Well, you lose. Okay, so it sounds like that was a 6-3 and a very glorious decision indeed. And it may not end up this way. We may come back and there may be various components of the executive order that are blocked or ultimately not implemented lawfully or legally. But right now, Indira Talwani just got obliterated. This was the case right here that we saw they were ruling on. Indira Talwani, actually, I think it was the DC case. That's right. It was the DC case. So this one actually came not out of Indira, but out of DC. And I think that might have been the Sparkle case, now that I'm thinking about it. So that was the Sparkle Suknanan case. And let me just confirm this all came out very quickly. And yeah, so I've got that docket, 139 here queued up. California. No, that came out of Massachusetts. Okay, so there's so many of them. And it may actually have been Indira as well. There were so many of these cases, but you get the point. Lower judges blown out. Activist judges crushed today. And I wanted to pause and just see if Mark Elias is crying about this right now, because he probably is. Let's see what we got. And yes, he is. He's recording an emergency podcast right now to explain what's going to happen. My advice is to subscribe to my YouTube channel, is what he said. So this guy is behind the League of Women Voters. His law firm represents a lot of these groups. He said, breaking, the Supreme Court has allowed President Trump's sweeping attack on mail-in voting to go forward, bolstering his long-running efforts to restrict voting access ahead of the midterms. Oh, it's like music to my ears. It's beautiful. The madder Mark Elias gets, the happier we are. There's a directly correlated inverse relationship, and it's just a beautiful thing to see. So, big win on that. Let me see if there's any other noteworthy post about this and any other alternative takes. SCOTUS Wire also did some analysis. Chuck Schumer's crying about it. Let's go. Chuck Schumer's very mad. Here's what Chuck Schumer had to say. Let's just indulge for a minute, shall we? It's a disgrace that the highest court in this nation is allowing Trump to put a dagger into the heart of our democracy. Oh my gosh. Why? By just making sure that the mail is being conducted with some actual oversight? Now he's turning the Postal Service into voter suppression, and his MAGA Supreme Court is taking action. Trump's effort to stop mail-in voting is election interference. It's so ridiculous. These people are so dramatic. Cry harder, Chucky. He wants to make it harder for Americans to vote. It's not harder at all. All you got to do, it's the same thing. You still cast your ballot. You still put it in an envelope. All we're doing is tracking the envelope. That's it. Senate Democrats will fight every attempt to hijack mail-in voting and rig the rules before voters have their say. Oh, it's so good. So Time says the Supreme Court allowed the Trump administration to proceed with plans to restrict mail-in voting. It's not restricting it at all. This clears for now an executive order that creates citizenship lists and directs the Postal Service to decide who gets a mail-in ballot. Absolutely outstanding. Let's see if the president has commented about this or if the White House has commented about this. Nothing from the president quite yet. Let's see if we got anything else that's out there. So enjoyable. It's just caterwauling. They're just moaning. Senator Pencilneck said the Supreme Court strikes again. This is the Roberts Court legacy. And CBS News is commenting on it. Anyone else? MS Now, fuming mad about this. Anything else that is out there? Just want to make sure we get some good reaction here. Mark Elias is doing an emergency broadcast. Let's see if they're live right now. No, they're not live. Go live, Mark. Read it on the air like we did. Yeah. So he can't do that, though. So let's see. Gavin Newsom says California is going to sue again. Of course. Newsom says, wow, the Supreme Court just let Trump move ahead for now with its plan to disenfranchise voters. You mean illegal voters? Illegal alien voters, non-citizens, people who shouldn't be getting multiple ballots. They're the ones who are all getting disenfranchised. Rightly so. California will be suing again to block these Orwellian rules from being implemented. Yeah, as soon as the order goes into effect, let's not get over our skis here. They're going to sue again. They're just going to wait until it goes into effect. But then it will be in effect. And then the burden is on them to show the illegality and how they're out of compliance with the law. CNN, Democracy Docket, Brian Krasenstein says this is election interference. Wow, we got a lot of election deniers now out there on the left. Amazing. And Joe Walsh is very mad about it. SCOTUS Wire. So great. And let's see what else we've got. We're just going to pause and indulge here for a minute. Yeah. Let's see. Anything else? Then we'll move on. Caitlin Collins will have our latest reporting tonight at 9. Don't watch it. Stephen Richer, the Arizona former Maricopa County recorder. Scott McFarlane. All right, so the left is like really going wild right now, but we're not seeing a lot from the White House. Let's see if we got anything from Rapid Response. And also not a lot of analysis yet on the cables. All right, so we may come back on that, but very, very nice decision. And we're happy to see that happen. So 6-3 victory. Supreme Court saying you can't sue and block the executive branch unless there's some actual harm that's happening. And we saw a very similar type of ruling with the ballroom. You know, a lot of these things are being filed by plaintiffs who really have no legitimacy to do it at all. The states are not going to be harmed, doesn't even implicate them. They want to use the federal government to send their fraudulent ballots. They can't do that anymore because Trump is in the House. So, tremendous win. Thank you for joining us as we got to enjoy that fresh out of the oven. And we'll see what the fallout is, what the White House has to say. But now I think this will spread to all of the other plaintiffs. This was the state case, but we've also got the League of Women Voters. We've got the NAACP. We've got multiple jurisdictions, but the principles remain the same. You're arguing about things that haven't happened yet. The law that is being contemplated and implemented is saying follow all the rules, and you can't step on the toes like you've been doing. So tremendous victory. The red states emerge. We've been covering this one for months now, since March, and it feels good, baby. So thank you for joining us as we got to enjoy that together. Of course, we're going to keep our eye out on this one. We'll see what the follow-up looks like and enjoy the win this evening. All right, so good stuff on that. Let's see if there's anything else that is dropping. And it's just great. Feels good, feels good, man. Yeah, on the other case, let me just look this case up real quickly. Because it was Massachusetts. Let's see where that one was. Nope, it wasn't that one. I wanted to see who the other judge was. Let's just grab this real quick. Slight pause on this matter. And I'm going to copy this case number because I wanted to see who this was specifically on that underlying case. Searching, state of California. It was Indira Talwani. Yeah, okay, so we were right about that. So Indira Talwani is the judge right here. The case number is this one, 11581. State of California versus Trump. She's also, I believe, got the League of Women Voters case. So she's got two of these things, and it is Indira Talwani, the Obama judge. She just got obliterated, rightfully so. Tremendous day. And let's see. Good stuff. All right, man, I'm like just vibing right now. Vibing. Good stuff. All right, so let's, we got some other news that is out there and some other, I think, interesting cases. I kind of feel like I'm just so excited for this one. I don't want to leave the story. And we'll see if there's any other. They're not even talking about it on the cables. Fox News has Nevada burning. CNN has Pentagon fires Stars and Stripes leaders. MS Now is on commercial. Nobody's even talking about it. Wild. All right, so very good stuff. All right, so we do have some other topics to get to today, and they're a little bit shorter, but not nearly as exciting. But we'll come back, so stick around. We'll do another recap. We'll do another little search to see if there's any other reaction that's out there from the White House and come back on the tremendous victory today. Feels so good, man. Cheers, my friends. Cheers out there to election integrity. Cheers. All right, so we've also got some H1B news on the day. And then Mamdani is being sued. And then we'll come back and we'll do another fresh round of SCOTUS victory laps. So here we've got this story today. H1Bs just got a lot more expensive, over $100,000 each if you want to come into the country and steal a job from an American. Homeland Security and USCIS now proposing a new rule, and they say that it's going to cost you $103,000 for all H1B cap subject petitions, including those for the advanced degree exemption. This one dropping today, saying the proposed fee would be paid at the time of the filing and would be imposed in addition to all other applicable fees and payments. Used to be a lot less than that. And if you want to have this person here so bad, if they're so amazing, if they're bringing skills that Americans can't have or develop, then you're going to pay for it. The fee would generate revenue to recover a portion of the federal government's costs for administering immigration systems. These costs include adjudication of benefits, fraud detection, like we have to give immigrants benefits for some stupid reason, fraud detection, national security vetting, systems modernization, record and others, court, consular, visa processing, labor standards, and coordination. And with this new fee, which is a proposal right now, we're going to generate $8.8 billion annually because right now we've got 85,000 of these people coming in every single year. So they said, this guy, spokesman Zach Kaler, said the proposed fee is intended to recover the cost incurred across federal government. We got to vet, we got to support lawful immigration programs, and the taxpayer funds them. So under this proposed rule, the fee would not apply to H1B petitions that are not subject to the cap, like petitions filed by certain nonprofit research orgs, government research orgs, institutions of higher education, which it should be applied. The number of cap subject H1B visas issued annually is limited to 65,000, with another 20,000 who've earned a master's degree or more. So the rule has now dropped. You can see it's a big fat rule, but it is being contemplated right now. So there'll be a lot of comments about this from all the foreigners and illegal alien loving leftists, saying, if you want to send in some comments, here's how to do that. And guess what? Your comments must be in English, okay? Or an English translation must be provided. We're not reading your foreign language. This is America. So they've articulated exactly what's going on here. And the details in the executive summary are as follows. The purpose of this rule, which is proposed, is to generate dedicated revenue to actually support immigration. We now have a fee payable at the time of filing, so we can recover a portion of the cost that we incur to do all this nonsense. The immigration system is largely funded by user fees, and there's a lot of costs that we need to pay for, adjudications and more. So Homeland considered whether to propose recovery of our related costs by adding a fee to all benefits requests or certain requests. We considered increasing the existing fee rather than establishing a separate fee. And so now we're proposing to add a fee. We've considered a lot of options on how to pay for this, and this is the solution. Now, we've also got a lot of authority to do this. 8 U.S. Code 1101, Homeland Security Act of 02, all says we can do it. And so now what we're proposing is $103,000, $265 additional fee on all H1B cap subject petitions. It's going to fund everything. $8 billion directly supporting activities that are conducted by CBP, ICE, EOIR, DOS, DOL, Immigration Court, visa processing, labor standards, activities between ports of entry. We've got a lot of ability to do this. Secretary is authorized to administer and enforce immigration. Other provisions say specifically, because they're going to sue over this, that Section 286M of the INA, 8 U.S. Code 1356M, authorizes the Secretary to, quote, set fees for providing adjudication and naturalization services at a level that will actually pay full costs for providing those services. 100 grand's a good place to start. Another provision under subsection N also says that this permits reimbursement and any appropriation, the amount paid of such for those expenses for immigration adjudication, and subsection G, 3 of them, saying we can actually prescribe rules to carry out the fee provisions, so we can do this. With a few exceptions, the fees collected all relate to exactly what we need to pay for in order, so they're related to what is happening. H1Bs come in, we got to pay for the actual processing of them. And in 2025, the IEFA accounted for approximately 98% of total funding, or $7 billion. The remaining funding came from appropriations, and the fraud prevention are also both funded by the dollar amount set by law. So we can't adjust those fees. We also have an integrity fund. We can adjust some fees and others, but this one we can. Now, as discussed before, the law permits reimbursement of expenses, and we are going to be doing that here. Now, we know that this fee increase is significant, so we propose this cost-shifting approach with an emphasis on the ability to pay, saying that when the petition is filed, Homeland does not believe the fee. If DHS does not believe the fee that the employer must pay is significant compared to the petitioner's wage obligation. Yeah, exactly right. So if you want to bring in an H1B'er and you're going to pay them 60, 70, 100 grand, then this is related to that. Homeland also acknowledges that it has historically spread unrecovered costs for free services and waived fees, but Homeland has considered the relative ability of different fee-paying populations to bear the costs, so the employers will pay this, by and large, if they want to bring these people in. We also recognize that petitioners may object to paying a fee that recover costs far beyond the adjudication of their petition, but our fee schedule has also said that we're allowed to collect not just for you, like the fee doesn't just process you, it manages our immigration system as a whole. So yeah, your application may not be actually costing us 100 grand, but the rest of the immigration system definitely is. And so we got to generate revenue for that. Now we understand, yeah, this is great. We acknowledge that we may see a reduction in the number of H1B registrations. Yeah, that's the point. And some employers, including small entities, may file fewer petitions as a result of this rule because it's too damn expensive. Just go hire an American to do it. However, the success of the fee model is generating revenue and at the same time balancing goals of administering the immigration system in total. So we arrived at this amount by calculating the amount that would be needed to add the fees for Form I-129, doing a bunch of calculations to get to the total number. And this is great news. So Congress has established the limits on the number of foreign workers. We can adjust the fees under current regulations. They must submit a registration, a prospective petitioner that properly is registered for a beneficiary, and so on and so on. ICE handles a lot of this. CBP handles a lot of this. There's all these different agencies so that we can have our country invaded. And so the rule now goes into effect. It is proposed. It will then have public comment, and then presumably it will be sued, and then it will go into effect, hopefully, very, very soon. So you can see it just goes on and on and on, all talking about recovering the costs for implementing immigration proceedings. And so we'll leave that there, but we get the gist of it. $100,000, you want your H1Bs so bad, then you got to pay for it. Now, here was JD Vance out over the weekend talking about why this is so problematic and articulates a problem that many of us have seen and many have documented, where certain companies like Microsoft or Xbox will fire a bunch of actual Americans, then go and apply for another 5,000 H1Bs to come in and replace everybody. JD Vance communicating exactly how that happens.
Up here, I remember when somebody would come to school and tell me that their dad had just found out that he had lost his job, that the factory that employed their parents was going overseas to China or to Mexico. In other cases, American workers didn't just have their jobs destroyed, they got told they were being replaced by a foreign worker, and then they had to train that worker before they got replaced. Some of these stories have made national news, and they've stuck with me. 3 years after the Wall Street Journal called for the free movement of labor, a computer programmer, not a mill worker, a computer programmer by the name of Kevin Flanagan was let go at the bank that he worked at. And the bank, they told him, you're only going to get your severance package if you trained a foreign replacement to do your job instead. And it's a heartbreaking story because he did it. He dutifully did what he was asked to do. And on his last day, he packed up his things, he walked to the office parking lot, he got in his truck, and he shot himself.
Wild. Terrible. Terrible.
It's not just Kevin, as you all know. Now, economists have measured the ways in which the opioid crisis exploded in the very locations where jobs were shipped overseas. The open borders demanded by those same people brought some innocent people, of course it did. But we also know that it brought a lot of cartels, it brought the fentanyl trade, and it left us with millions of orphan children being raised by aggrieved grandparents. That was the story, of course, of my mama and papa. Now, the blood of these men and women, these so-called deaths of despair, I'm sure you've heard that phrase, but it's almost too abstract for me, because the blood of those people, in my view, it pools at the feet of those who would sell out their country for a cheap bottom line. Our politicians, and frankly, the cronies in the private sector, people who didn't want to build in America like Cleveland Cliffs, but people who were happy to build overseas, they got rich, and communities like this one got poor. Politicians, think about this, who came to Washington with a few $1,000s in their bank account, left after decades of public service with millions in stock portfolios. And what did all of you get? What did we get? If you were lucky, your neighbor's job got shipped to a foreign country while your tax dollars got shipped to fraudsters. And if you were unlucky, as I know many people in this room were, you were left raising a grandchild while you were mourning the child killed by the very poison brought across that wide open border. But just as it was a policy choice to let that happen, my friends, it was a policy choice to reverse that decline.
That's right.
And in November of 2024, you made a choice to reverse 40 years of American decline and make Donald Trump the President of the United States.
Let's go.
And I'm not saying it's going to be easy or it's all going to happen overnight, but in just 18 months, we have seen an explosion of rebuilding in the American heartland. We have seen trillions, with a T, trillions of new dollars of investment pour into the United States of America to build new smelters, build new manufacturing facilities, build new mills, build new everything. Under President Trump's leadership, factory construction employment has exploded. We've added 83,000 factory construction jobs just since Inauguration Day.
J.D. Vance explaining exactly something that many of us have seen and experienced and seen from our friends and family and the people that we love. And now it's coming to a close. You want to continue to import people to replace actual lifelong workers like Xbox did, then you got to pay for it. And at $100,000 a pop, I don't think it's any longer economical for them to do that. So hopefully this rule continues to advance, gets ensconced in law. There'll be a bunch of lawsuits that come out against this one as well, just like the last time they did this. But every time they identify how they can do it or how they can't do it, it sharpens the blade a little bit more, and they're able to enact the policy that hopefully sticks. So we'll keep our eye on this one, my friends. Thank you for joining us and subscribing as we do. All right, one more update on the day, and then we'll hear from you and continue our Supreme Court victory vibes. But this one is also, I think, a pretty good segment, so we'll just squeeze this one in here as well. New Yorkers are furious with Mamdani, and they've unleashed two separate lawsuits, one of which is a class action, saying that he is discriminating against them by creating communist grocery stores that actually harm their businesses, slapping down what they have built over their lives. Many of these owners of these stores are minorities and other people who are, according to Mamdani's ideology, dispossessed of part of the American dream. And then Mamdani came in and dispossessed them even further by subsidizing a government entity at the expense of the businesses who don't get an actual check from New York City to pay for and lower their prices of their goods. So we'll see two different lawsuits that are now being filed against him, both of them in short form. But the background here, and to add a little flavor to this, comes over from Fox News, who explain who these people are. One of these guys is an East Harlem grocer who says that he's getting hammered by Mamdani, and he's not happy about it at all.
Well, new this morning, a group representing immigrant-owned grocers is suing New York City over Mayor Zohran Mamdani's plan to open 5 city-owned grocery stores. And Fox Business' Madison Allworth has the details from East Harlem, New York. Hi, Madison.
Hey, good morning, Dana. Yes, the Multicultural Business Coalition. They represent 50 chambers of commerce and multiple small businesses like the one behind me. They are officially suing the city over this plan. Essentially, they are arguing that they're taking taxpayer dollars, like dollars from the business owners behind me, and putting that into those city-run stores, which as a result won't have to pay anything in taxes, which will make it unfair in terms of competition.
Crazy.
They haven't done any business investigation as to whether or not these will work, and as a result, they're asking the state to stop this. We spoke to Elvis, who is the manager of this store behind us here. His family has owned it for 25 years. He's featured prominently in the lawsuit because I'm going to spin around and show you this empty lot just across the street from his store. That is where the city-run grocery store La Marqueta is going to go in 2029. That grocery store will open just across the street, and it will not have to pay anything in taxes. He says that alone is going to be too difficult for him to compete with and will put him out of business.
The city pay, I'm paying for him. I pay tax. Pay for him. So it's not good. He don't give me the license for the tobacco. I have no license for the tobacco. I ain't got to pay rent. I got to pay insurance. I got to pay tax. Never require tax. Tax is so expensive.
It is expensive.
Now, we reached out to the city for comment regarding this lawsuit, but have yet to hear back. But they have recently walked back some comments regarding government-run stores here in New York. The lead official for NYC Groceries told New York One that they were exploring grants for local businesses to help them compete with the government-run stores. So taxpayer dollars going to city-run stores and to the stores that already exist. But the mayor's office has since walked that back, telling Fox Digital they are not considering grant programs for existing grocers. This location across the street, the city has set aside $30 million. As a reminder, we're talking 5 stores. The city says all of them will cost $70 million. This one alone costing $30. But now they do have some pushback from small bodegas and markets like the one behind me.
Very interesting. I wonder who that guy voted for, presuming he's a citizen. Do you think he voted for Mamdani, or do you think he voted for the guy with the hat? Probably Mamdani, if I had to guess. So what we're seeing is this new development where the left is probably eating the left. And now you're seeing that they're suing Mamdani, saying this is racist and it's attacking us. The Multicultural Business Coalition, who normally comes out, these types of groups, and sue the right, saying you're racist and bigoted against us, now suing Mamdani. They filed this one saying this is a judgment for stopping Mamdani's grocery program. We want an injunction until the respondents have undertaken the necessary land use and review study. Because they're dealing with controversial and consequential economic development plans. They're going to destroy our small businesses, our stores, our bodegas, and our supermarkets. We've put in our own private capital. Well, that's why you shouldn't vote for communists, because this is what happens. They come in and they destroy you. They subsidize their own businesses, you get destroyed, and then you have to go to their grocery stores as they take over everything. Operating in the vicinity, oh no, where the member grocery stores are predominantly owned by minority groups. Mamdani is a bigot, inclusive of Hispanics, Arabs, and Asians, all getting obliterated by communism. We told you. So in spite of the obstacles before them, these business groups have been extraordinarily successful at providing healthy food. Further, the New York grocery program, if they're not doing a study, then it could lead to the further exclusion of minorities. From Mamdani? Is he a white supremacist? That have overcome disproportionate obstacles to their successes. Yeah, it's always disproportionate, we know. So accordingly, for these reasons, we respectfully ask that they issue an injunction permanently blocking Mamdani's grocery stores. And now, what are these judges going to do? Oh my gosh, it's like those two buttons in that meme. Like, are they going to rule against their hero communist, or are they going to rule against the Multicultural Business Coalition? What are they going to do? It's a disaster for them, because either way, they're violating their woke bona fides. So here we've got a not-for-profit entity, Frank Garcia, president, all these people. Now we know Mamdani unleashed his affordability agenda by taxing everybody to pay for food for other people who can't afford it, so-called. Saying 5 grocery stores, he's going to sell food at 30% below market rate, all subsidized by the government, and the stores don't have to pay taxes. So now you, as a regular business owner, you got to pay full market rate to get your goods and sell them at market rate, because the market should set the prices. And you also got to pay taxes on top of it. And in addition to, income and sales tax, you also got to pay property tax and pay for all of your utilities. You're totally hosed. Therefore, we say that they do not meaningfully regulate affordability on a need-based method. And the deeply discounted food items would also be available to uber-rich New Yorkers. There's no actual measuring on need. And homeless New Yorkers, they're all going to get the subsidy. So the overwhelming consensus, regardless of class or party affiliation, writes the Multicultural Business Group, is that affordable food is an excellent idea. There's virtually no doubt or debate in that regard. However, the issues before us arise because this is a classic example of contemporary globalization, which began in the 1980s with the increasing spread of the U.S. version of capitalization and neoliberalism. And so now the current grocery stores have resulted in smaller grocery stores predominantly owned by minority groups. They're historically excluded from the economic opportunities. Well, now you're going to get excluded even harder. Well done on voting for communists. So the market now departs now that strongly supported minority groups are owning these places and they're being excluded again. The grocery stores of Mamdani are no longer taking studies. They're not analyzing the adverse effects that this may have on minority groups. They've not undertaken to study on what's going to happen when they put these locations in and then all of the other grocery stores go out of business. These reports also evaluate local food deserts and track program intact. So it's beyond debate that these new stores are going to compete with us, including our members. We have been historically discriminated against, and just get ready. It's going to come even harder because we run grocery stores that are barely making profits anyways and are sometimes not operating in the red. So no studies have been done. And these other people have run Hispanic and Korean markets, all going to be in competition. So we can't, as minority members, compete with these stores. We're going to be put out of business. Yeah. So now, without any studies, without any idea about how harmful this will be to immigrant and minority businesses, we've long refused to even allow Walmart to open any stores. Yeah, Walmart also had to meet certain costs and turn a profit in order to stay open. You're getting hosed even worse than Walmart. Everything in these new stores is going to be subsidized, and so you're really cooked now. You want your Walmarts back, saying that they've pledged to, they just made that point, pledged to sell food items below 30% market rate that even rivals or exceeds Walmart's discount. Yeah, you'll be begging for Walmart back after Mamdani's done with you. So now we're suing, saying the creation of all these things are in violation of the law. The decision to open these stores is arbitrary and capricious. You know, bad faith is shown here, and they haven't taken a look at these effects. It's going to have discriminatory effects. His stores are racist, which is their main argument. So now it's clear that despite pursuing a noble ambition, they are not acting with a sound basis in reason. That is for sure. And without a study to show how bad this is going to be. It's going to further enrich multi-billion-dollar businesses and eliminate opportunity for minority businesses all across New York. And so therefore, you should permanently enjoin them from opening up these stores. And that's just lawsuit one. The next one is very similar to this. And is this the same one? Maybe these are both the same filing. No, I think this one is a little bit different. This one looks like it's another lawsuit, but same multicultural business association as the plaintiffs. Let's take a look. Is this case different versus the first one? Scrolling. That's the petition. This is the complaint. It's the same argument. Same plaintiff, the MBC, and a civil rights consortium. See if there's anything different in here. Venue summary, parties, factual background, grocery stores, 30% under market. Yeah, a lot of it is very much the same. Yep, it's the same. Okay, so Mamdani apparently is destroying minority businesses like a good communist would. And I would expect many of them voted for him, probably celebrated for him, probably did cartwheels and backflips over his election campaign victory. And now they're getting blown out because communism comes for everybody. And once you start to promise all of these different groups that you're going to take care of them at some point, something has to give. And one group needs to be favored and elevated over the others, and then you get destroyed. So this is how it works. Hopefully this is a wake-up call. Hopefully we all learned our lesson now. We don't vote for communists anymore, but that is a hard thing to ultimately get into people's heads. So Mamdani was asked about this. He said, yep, we're going to keep opening these stores. I don't really care because we have a bigot, anti-minority governor in New York City now.
I continue to be fully confident in both the legality and the importance of our initiative to deliver 5 city-run grocery stores, 1 in each borough, to the people of our city. We are talking about a reflection of a cost of living crisis that has seen grocery prices increase by about 30% over the last few years. And we're also talking about delivering 5 city-run grocery stores in a city of 8.5 million people that has more than 1,000 grocery stores. And we've seen, in fact, with Essex Street Market in Manhattan, as well as Moore Street Market in Brooklyn, a model where the city has subsidized groceries and it has not had a negative effect on bodegas around them or on grocery stores around them. And I'm confident both in the legality of this, that it will stand up in court, and in the importance of delivering it.
All right, so Mamdani hates Hispanics and Korean business owners. Makes sense. So they're suing. Beautiful to see a little bit left on left, litigation happening out there where many of them probably voted for this guy, not realizing he was going to come end their livelihood permanently with his Marxist ideas of providing low-cost food to certain people and having other taxpayers subsidize it. So we'll keep our eye on this one. But New York has started the dissension into communist hell. And eventually, this type of internal battling will continue. And we'll keep our eye on it. Thank you for joining us as we do. All right, so if you're just getting here, we had a very exciting day today. So we talked about a couple of things. First segment, in the can. We were talking about the Supreme Court getting a new complaint or new supplemental from the DOJ saying, we need you to stop this from happening. And then while we were in the thick of it, boom, SCOTUS delivered in a 6-3 decision. They said that the lawsuits brought by the states in this matter were illegitimate. They did not have standing. Their cases were not ripe, and the stay has now been granted. So the lower court blocks are now nuked. A lot of this will continue to be litigated. We may ultimately lose some portions of the executive order. I hope we do not. We're going to stay positive on that. Hopefully they all go into effect, and the states that have failed to show any actual harm here will continue to do so once the orders are in fact implemented. So great win from the Supreme Court. All the right people are upset about it. We saw Mark Elias crying about it. Norm Eisen said, we're going to sue as soon as it all goes into effect. But it also symbolizes the big problem that we've been covering here since Trump took office in 47, is that these lower judges just do whatever they want. They really don't care. They have to wait and stall everything out until the Supreme Court has to come back down and give them the old SCOTUS backhand. And in the process of delaying everything, they take our governance away from us. So thank you, SCOTUS, for setting this right. Another tremendous win. We talked about the underlying rule. The rule went into, it wasn't into effect, but they published it over the weekend. That's what caused Indira Talwani and others to have a meltdown. And then suddenly SCOTUS slapped them down. It was a good one. Then we talked about Ilhan Omar. Apparently she's under a criminal investigation or maybe other types of investigation. But the folks over at Just the News submitted a FOIA request. They got denied access to the files that they were asking for, largely because it is currently being compiled and used for law enforcement purposes, so they can't hand them over, which is delicious news. Ilhan also sent this nasty gram over saying that they identified an undercover Homeland Security investigator who was outside of one of her campaign events. They were very mad about it. Ilhan seemed extremely annoyed and was asking, where else were you surveilling me? Can you tell me what else you were monitoring in case I was committing crimes so that I can cover that up as well? Sent that out. And Steve Miller was here explaining exactly how this entire scam works. We then talked about H1B visas going up to $103,000 per head. If you want them in, you got to pay for them. JD Vance shared a story that we've all seen happen in America. We took a quick look at the rule to see exactly how this would be implemented and what it said in the details. Then we got Mamdani now being sued by presumably his voters, saying this is a racist attack on our business. You didn't even study anything about how this would implicate us or what this could do to our livelihoods. And of course, Mamdani doesn't care, because why would communists do that? All they care about is imposing their agenda, not actually making things more affordable. Not going to be more affordable for these small businesses when they have no businesses. You know what I mean? So they're going to be out on their bums, but everybody else will still be paying to subsidize the food from Mamdani's government-run grocery stores. Total disaster happening out there. But now, my friends, it is time to hear from you. Haven't seen a lot of reaction from the White House on the Supreme Court victory. Let's take a look to see if the president has dropped anything since we last checked. And nothing yet. A couple of posts a couple of minutes ago, but mostly memes and other things. So now it is time to hear from you. Let's see what you say about all of this. Thank you for joining us for that very exciting day, man. I was very excited about that. Don't know if you could tell, but it was a good one. So let's see who's joining us. I saw we got a bunch of new members coming in. Thank you for bringing our new members in. We had a great morning stream today. We talked a lot about various things. We did an Irina Zarutska update. Her family is now suing the city of Charlotte for wrongful death, which was interesting. We also talked about Carmelo Anthony. His motion has been denied for the new trial. We got into that. And we talked about the census. There's a group of over 140 various lawmakers who are demanding, or not demanding, but asking that the president appoint somebody to lead the Census Bureau. so that we don't have a rigged census in 2030, which I think is critically important. So all good stuff there. And here's Ilhan. Oh, Ilhan, she's mad that she's going to be put in the mail. Oh, no. Poor Ilhan. Well, that definitely, if you sent Ilhan in a mail package, that would definitely be mail fraud because she's a fraud. Thank you for that one. Trump with the thumbs up. Thank you, Mr. President, for making sure that package does not get delivered, return to sender, or at least send it back to Somalia. Slimmer Stubby, what's going on? I hope they reply to the judge that she caused the emergency by illegally and unconstitutionally inserting herself into a matter that she has no business nor jurisdiction to get involved in. 100% true. Yeah. It's always election chaos. We're always too close to the election. It's always needing to hit the emergency docket. That was Ketanji's main point. This has turned into a mess. If the judge at the outset would have just said, no, you can't sue. You have no standing. Follow the jurisprudence and the precedent that has been on the books forever, rather than acting as an activist judge whose only goal is to prevent the administration from accomplishing their goals. None of this would have happened. The executive could have continued to do their job and there would be no separation of powers problem, but they did that. Now they're mad that their judge caused the chaos. Yeah. Thank you, Slimmer. Hey, what's up? Kim O'Connor sent a gold coin. Thank you, Kim, for doing that. First Amendment. Rob, thanks for answering my question last week. Locals coin is back up and running. Man, thank you, First Amendment. Hopefully it was a sufficient answer. I don't even remember what it was, but I'm sure it was a tremendous conversation. Thank you for keying us off. And thank you for the donation over on Locals. Smooth Brain Crypto. Children's Health Defense versus FTA was denied standing on the exact organizational grounds League of Women Voters is now using. Yeah, I mean, I think that's going to be the takeaway here, is that all of these other, ancillary claims like, oh, we have to change things. We have to modify our website and write new literature and train people and issue new guidance and all that. That's your problem. And that's your job, by the way. So how is that an irreparable harm to you? The government can change things unless it's inconvenient for somebody and they have to do something to modify how they deliver their services as an interface and a liaison to the government. It's why it's not standing. It's the dumbest thing ever. But they create these groups, and largely it's been indulged by the courts for a very long time now. So it's nice to see the Supreme Court anchoring in some standing limitations that will hopefully continue to be enforced. Tim Jake, what's going on? Fox News reporting that the Supreme Court allowed the Trump admin to enforce revised mail ballot restrictions. 5:13 p.m. reporting is 6-3. Man, thank you, Tim. Yeah, I just saw those come whizzing by. Thank you for flagging that for us so that we could absolutely get into that goodness today. Really good. Thank you, Tim, for the heads up. Sandy, same thing. Thank you. Looks like SCOTUS responded to the election case already. We appreciate when they do that. I kind of envision in my brain that Clarence Thomas is watching the show and he's like, oh, this would be a great segment for Robert. Thank you, Judge Clarence. We love you. Thank you for your assistance in the show. We appreciate it. So they publish it so we can enjoy it together. It's really nice of them to do that for us. Thank you, Sandy. Hey, not a Fed. Just saw Gateway Pundit posted the same thing. Supreme Court upholds Trump's executive order restricting mail-in voting. And it does feel good to be vindicated, Again, we don't know on the merits where we'll get on this. Hopefully it is very successful. But we were saying this whole time, how can these people even sue? There's nothing even happening. It was ridiculous. And then it's total victory, domination, and demolition of the other side's arguments. What a great day it's been. Hey, Anthony Bray, what's up? Sent in a brain, it looks like. A 100, sent a 100 little emoji. And a little baby, a little person hiding or something. Thank you for that. Lynn Reiber in the house. Thank you guys for sending in those, what do they call gems, jewels? What do they call them? Thank you for sending them. Hey, MCM. Thank you, MCM. SCOTUS update on mail-in. Trump victorious. Boom. We did it. So good. Thank you, MCM, for the donation. And yeah, man, you guys flagged it for us. We really appreciate that. Otherwise, I would have missed it. I'd be like, yeah. I have no idea what's going on. So thank you for flagging it. Hey, Picaspi says, stay hydrated. Definitely could do a better job at that, especially during the streams. Thank you for the heads up. Hans, what's up? Breaking. SCOTUS lifts the block on the mail-in ballot changes. Let's go, Hans. Thanks for sending that in on Rumble, too. Amazing. Friends, thank you for all of the heads up. We got Good Game Keys. Good Game Keys from Boycott China in the House, spelled appropriately. Gauntlet KI, my mailman threw away my 24 absentee ballot. WTD. Yeah, that seems like that's a problem. And that's why we got to track these things a little bit better so that the Postal Service workers who are committing $23 million in check fraud don't just start frisbeeing Republican ballots right out the window on their way home. Sorry that happened, Gauntlet, but hopefully it never happens again. Hey, Lady Laux, what's up, lady? Thank you for being a member and for the nice dono. Says, can we the people sue Congress and the Senate to force them to pass the Save America Act? Unfortunately not. It is an 80-20 issue and the majority is being ignored. I personally have had enough of DC ignoring the American citizens. Yeah, such a good comment. I feel the frustration out there. But the answer, unfortunately, is no. I mean, fortunately and unfortunately, it's no. It's like if we could sue, then everybody else could sue for every other thing they wanted done. We talked about ripeness and standing, but in the justiciability category, can you sue before you even get into court? Really, you have to reach a threshold. Yes, you have a right to be here. Standing, mootness, ripeness. You've got estoppel like latches. The other big one is called a political question. A political question is something that's best left to the political branches. So the response from the court, if you tried to file something, would be, we can't help that. Like we can't force Congress to go make a vote. That's a political thing. So go get your senators to vote or go run for Senate, right? Like it's part of the political process. And it would be a separation of powers problem anyway. Like the court, you sue in court and the court then orders Congress to do something. Right, that's why we have a separation there. So long story short, the answer is no. It would feel good, to file a lawsuit and sign off on that. But otherwise, it's a political issue. So the courts can't get involved in that. And they don't. They'll kick the cases out. They'll say, go complain to your senator. Go sue your senator. That would get dismissed too. But otherwise, the right avenue for that type of complaint is to go engage people in the process, get people excited about the SAVE Act. Part of what you're doing here is that exactly, articulating your support, engaging with fellow Americans, using your voice to explain what's important to you, and really staying engaged in the process so that we can ultimately, rally enough people to our cause and then hopefully get it done. So, lady, you're doing it already. Thank you for being here and for your support. Jeffrey Adams, what's going on? This is why I follow as a member watching the Watchers. Nice work, Rob. Today was a good one. Today was extra good. Man, I'm still jazzed from that. Love it when it happens and it coincides. And it worked out pretty good timing. We had just finished the actual request. So it was great. We love it. Thank you, Jeffrey Adams, for being here, my man. We appreciate that. DC Metro, what's up, DC? 27 months as a member. That's multiple babies. We appreciate you being here, DC Metro, for so long and sending us some love. Hopefully your day's amazing. Dan, what's up, Dan? Coin purchase function has been resolved. That's incredible news, Dan. Over on Locals, they had a little bit of a tube problem over the last couple days, but thank you, Dan, for the heads up. Glad it's working. Hey, the average mountain man. What's up? The average mountain man over there on a mountain, doing the slide on the mountain. What's up? Bringing in 10 new members. Can't wait to see everybody tomorrow morning, 10 a.m. Eastern time. What's up? Mechanic Jams. We got Jim Bob Browning. Welcome. The Odor E. What's up? Roland. We got Hawkeye. Paul J. Hall in the house. What's up, Ghost Gaming? Mike Beretzel. Welcome. And Renee Duncan, all gifted members, courtesy of the average mountain man in the house who happens to be a member and is bringing in 10 new members. Thank you, the average mountain man. Welcome aboard, everybody. Mock Schnell, amazing. Also, bringing in 20 new members. Thank you, Mock Schnell, for doing this. Welcome, new friends. What's up? Not Joshing Based. We got KD. What's up, Karen Gowdy? We got Skintown Steelers, Tad Nightingale, Anthony, Capo Lingua. What's up? Keeping it real. Welcome to the Jungle is here. We got B Banks. Laura, Danielle, what's up? Black Swan Traders. We got Chuck Norris, Tony Harris, Dank. Penny Hardenburg, welcome. Oysters, Dan Supter. We got Houston Patriot, Viva La Tom Rebellin. We got Calamitous G, Shane Souza, what's up? And Mock Schnell says, just a little gift to say, hi, been busy last few days. Hopefully those trades are going well, Mach Schnell, and you're raking it in. We appreciate you doing that. Welcome, new friends. Thank you, Mach Schnell, for bringing in 20 new members. And MCM, bringing in 10 more friends. It's a Supreme Court Victory Member Day, baby. Thank you, MCM, 21RN in the house for bringing in 10 new members. What's up? Mel Private, Yankee Doodle Stacker. We got Iceberg Slim, Queen of Petty, Mr. Harry Palm, Free Bubba, welcome. We got Article 4, Section 4, Jonathan Bearden, WNBA Youngboy, and what's up? Liz Fletcher, all coming in the house. What a beautiful day. Scott Ritter, good to see you. Sent a finger heart. Thank you, Scott. We appreciate that. Richard Tatership in the house. 5 new friends brought in courtesy of Richard Tatership joining us. Thank you, Richard. We got Shelly Babes. What's up? Sam, the Irish Texan. We got Sports Card National, Justin Michael USA, and Republican Bar in the house. What a lovely day it is. Thank you for doing that, Richard Tatership in the house. Lady Ice, what's going on, Lady Ice? Hey, Rob, how's Mama and Baby doing? They're both doing amazing. Yeah, they're both doing really well. I hope the little mittens I sent to Baby from scratching his face got there. I had a thought, we probably did, Lady Ice. We're working on thank you cards. We just ordered thank you cards with a nice baby photo of all of us that we'll be sending out. So thank you, Lady Ice. And there are a couple of people who I don't have emails or mailing addresses for, so I'm going to look you up and figure that out. Not a ton, but I got a handful of people. Hopefully it's not you, Lady Ice. Anyways, I had a thought about the morning stream, wondering what you thought about it. Do you think that Cash would be pursuing the case against the pipe bomber with the thought that it would uncover discovery and open the door to things being held back and not released on the alternative Capitol Guard lady? We know he still has a lot of holdovers embedded. Yeah, almost like it's a smokeout operation. Probably not. I mean, I think that honestly, like, again, my perspective on the Capitol pipe bomber case is that if it is true, if it is in fact not Brian Cole Jr. who did it, and it is, if the Capitol Police and the CIA were involved in January 6th, and maybe at an integral level, that rewrites the entire history of January 6th. All of the insurrection is now a complete government orchestrated hoax. It obliterates the deep state with one fell swoop. It would be like uncovering the true identity of the Kennedy assassin. Okay, it would be historic to say, oh, we actually found the officer by name, and gate analysis and other indicia that say she did it, and now she's at the CIA. It would be shocking. Now, I don't, go so far as to blame Cash and Dan for charging this guy. I don't really think it was their decision, probably. They declared victory when he got charged. I would imagine that they're so high up that they basically get, served the evidence, and they would just gobble it up like anybody in their position would and just say, that makes sense to us. They're not out there doing the investigations and the underlying work there. So I can make an argument on their innocence, that they wanted to declare a big victory. They wanted to come out, we got the guy, so on and so forth. But they also may be a part of the duping from the CIA. They delivered all this evidence. Maybe there's more nefariousness there. Maybe they're actually, being pressured and they know it's not accurate or whatever. I don't know. Can't speculate that far. But when people say that this is like an attack or a doomerism on the Trump administration, I don't go that far. I mean, it's part of a cover-up. Like the admin is, the case is currently being prosecuted by Jocelyn Valentine. She was a J6 prosecutor. Janine Pirro kept her around. So I think that it could have been Brian Cole. We'll have to see. It could be evidence there. But if it is in fact not Brian Cole and it is a CIA officer or person who did it, an employee, it changes everything. It's like earth-shattering news. So I think it's worth investigating, not as like a doomer black pill, like the administration sucks type of thing, but like a, wow, like this cover-up may go way deeper than anybody could even contemplate, right? So that's why I'm in favor of at least getting to the bottom of it. If it's not the CIA employee, then it's not, right? We just let the evidence flesh out. But this one's interesting because we don't have a lot of cases that end up like this. Like we've got a name and a face and a person and a motive and a gait analysis. It looks like a woman walking around. It just feels very, very plausible in a way that if it's true, if you identified it and were able to make the case concretely, it would shatter the entire narrative. And it would be like literal, actual positive evidence that they were behind it. And we've got a lot of other indicators of that, of agents in the crowd and guys like Ray Epps out there and Stephen Sun saying he was calling people, and Nancy Pelosi and her documentary and all these things. But this would be the most direct evidence that we have that I think would be just explosive. So, and I think that's in service of the legitimacy of the Trump administration and the American people. And they smeared all of us, by the way. J6 was a massive smear. We all got smeared. I got YouTube strikes, harmful and dangerous, didn't go to jail or anything, but a lot of people did. It's the tentpole hoax that I think if it comes crashing down, it rewrites history literally. So it's worth looking into. Hey, Sev Russ laughing at Schumer. Schumer, ha, ha, ha. I saw his whiny, moany post from Chuck U. Schumer. Pretty amazing. Thank you, Sev Russ. I thought it was hilarious too. Really indulging in their crying. Hey, Slimmer, I wish Trump would make an EO declaring aglets should no longer be manufactured from plastics and should only be made of metals. It'd be great to see all the leftists pitch a fit over something so inconsequential. Yeah, Trump could basically cure cancer and they'd be mad about it. Well, we like cancer. What's going to happen to the cancer doctors? Maybe cancer is good because it minimizes the population. An aglet is the small plastic metal sheath attached to each end of a shoelace that allows you to poke it through that hole a little bit more easily. Not a bad idea, Slimmer Stubby. I think it could be good. Effectual insurrection. Mark Elias is a horrible lawfare activist and a leftist hack. Couldn't have said it better myself. Alex Kaplan, LOL, I love it. Thanks for covering this, Robert. It was a good one. It was a good one. We were excited. And then Sandy, thank you for that. Effectual insurrection. Good comment. Thank you for the donation today. Sandy, Norm Eisen responds to the SCOTUS ruling. Norm says, please don't overreact to Roberts' court's decision on the contemplated USPS ballot moves. They simply held that the injunction came too early before a final rule. Now we have a final rule and we will litigate it. I'm as confident in our arguments here as in any of our cases, exclamation point. I mean, he's not wrong. They are going to litigate it, no doubt. And the court didn't approve all of the arguments or all of the merits. It just said their claims right now can't be validated. The rule, once the rule is in effect, they'll come back and make the harms. But the harms, the problem for them is that they've already alleged a bunch of harms, and the Supreme Court, in a way, did say that they're not really valid. Like, they did talk about it. It's speculative. It's this, it's this, it's this, it's this. But in the decision, we also saw that they said, it says, follow the law. And they said, you're going to prosecute us. It says, no, we're not. They said, you are if we don't use your list. You're going to prosecute us. No, you're not. So it's like not on the merits, but there's also hints about what their position is on the merits. And it was 6-3. So Norm should be a little concerned based on some of that. Like there's some tone and thematic decisions that I think you can glean from that decision. Even though it was about standing and the process where we're at now, there was also some takeaways, like you were exaggerating these harms. Nothing said that. Nothing said that they were going to commandeer your state rights. You said that they were. Nothing in there says that. So you're being very hysterical. Hey, C. Reed, LOL, I blame you, Robin. You honestly made my mother break out the popcorn. It's all your fault. Let's go, baby. Heck yeah. Popcorn it up. It's a delicious day to just enjoy it, like that Michael Jackson gif where he's just, eating that popcorn, baby, as all the leftists are melting down. So good. Honestly, they're still not talking about it on the cables. They're talking about Maha, RFK's on with Fox, Iran sanctions threat, dismisses sanctions threat on CNN, and Trump threatening Canada on MS Now. And BBC's talking about tracking the UK's rarest birds. I don't even care about the election. All right. Sailboat, what's up? Hey, 14 months as a member. Thank you, Sailboat. Banger of a show, Rob. Tell me about it. It was a good one. Thank you to SCOTUS. We'll take that. We'd like a lot more of that. Every day, we'd like that. Wouldn't that be great? Every day. Wow, another one. Amazing. We would never get sick of winning here. Thank you, Sailboat. Thank you for being here for 14 months. Amazing. Hey, Biltong is here. What's up? Get your Biltong. Turn up the flavor with Peri Peri Biltong, baby. Mild heat, big flavor, over 50% protein to keep you going. Try the full Peri Peri range at BiltongUSA.com and use code Robert, and you'll save 10% off and get delicious meats delivered to your door. And some other spicy sauces like the Viva and Barnes sauce. Winning reality. Here's what nobody is talking about. Nobody. Low-cost food is low-grade GMO fake food. Commies smile as you pay less and get poisoned more. Let them eat fake. Yeah, I'm curious. We read through like the RFP, the request for proposals, and like there's a basket of goods that they have to deliver. But yeah, I mean, the more processed it is, the longer shelf life it has, the cheaper it is to make because you're filling it with seed oils and stuff. And it's not necessarily good for you, right? You want kind of whole foods, clean ingredients, less processed the betters, meats, eggs, not drinking Coca-Cola every night, stuff like that. Winning reality. Thank you for the comment. We'll see what's ultimately in there, but regardless, it's going to be harming minorities in New York, according to them. Hey, Gary Baines. Hey, man. So how's the weather in D.C. this late summer? Honestly, this week it's been beautiful. Like, it's been gorgeous today. 78, something like that. Low humidity. Absolutely beautiful. So been very much enjoying it, actually. Thank you, Gary. Hopefully the weather's good over there where you're at as well. But it has been enjoyable. Taking our boy out for walks, little Axel boy. I'm like, wow, this is really great. What a beautiful day. Thank you, Gary, for the dono. We appreciate that. You up in Canada? Where's that coming from? Richard Tatership says, good times. Tell me about it, Richard. 100% true. Hey, thank you, Richard. What's up? Orchid Isle. Sent in a high five. High five back to you, my friends. Amazing to see you. Thank you for that. Orchid Isle. Sith. Hey, thank you, Sith, over on Rumble. Says, Rob, thanks for all your hard work. Thank you, Sith. Thank you for joining us. It's really my pleasure. It's an honor to spend time with you to go through these stories and especially these victories we get to celebrate together. So thank you, Sith. Thanks for watching on Rumble as well. Hey, Lady Laux, what's up? 2 months as a member. First month's the hardest. Gets easier from there. Thank you for explaining. Thank you, lady, for being a member and for joining us. Yeah, it was a good one. It was a good one. Hey, from Dave Katz. Rob, are you going to cover the Fannie Willis $16.85 million loss? How did I not even see that? We keep our eye on any Fannie news. And I haven't seen that one. What did she lose? Judge blocks Fannie from getting from 16. Oh, that was back in March. Is that still going on? Maybe she appealed that. I think maybe she appealed that one. Yeah, thank you for the heads up on that, Dave. I'll keep my eye on that one. We love covering some Fannie losses because she's terrible. So, Dave, thank you for the heads up. Natalie Ray, what's going on? Look at that photo. It's too beautiful of a day all around not to share the beautiful view off my deck. Enjoy these Tennessee mountains, y'all. That is a crazy photo, Natalie. That is amazing and beautiful and gorgeous. Wow. So it's almost like, is that like fall coming in? I'm from Arizona. We don't have a lot of seasons out there. It's like hot and cold. And regardless, our saguaro cacti don't really change leaves, So Natalie, that is gorgeous. What a beautiful photo. Soak that up. Mother Nature, the earth is so beautiful. Hey, K Bean in the house. 54 months, K Bean. You're amazing. Mod extraordinaire. Hanging out with us for so long and being such an awesome part of our community. We love you. We got, J6. We got the Screeching Lib and another J6 in the house. Amazing. K-Bean screaming at the sky as they are prone to do. Thank you, K-Bean, for being here for so long. We appreciate you. And thank you for modding the fort down for us. Hey, Sharpie Guy, what's up? Yeah, Sharpie Guy. Usually Monday is the Democrats' slant day on the news of the day, and it was so nice to hear them getting rocked by the Supreme Court. Woohoo! Please load my lip to Argentina positive points with my family that believe Elon's data center is a bad thing. Thank you and blessings for you, Alexis, Colorado, Mama G, and all your family, and of course the Watcher family. Man, shout out to Colorado. Maybe you mean Baby Cannon, but either way, Colorado's pretty amazing too. I mean, not really. But thank you, Sharpie Guy, for the heads up and for being here. And we appreciate that comment. Hey, Jersey Strong. Yeah, so this was... Yeah, that's interesting. So in that decision, I don't think that we saw... Yeah, that sounds like the CASA case. I think that was a prior case. Mind-numbingly technical query. I think that was the CASA case. ACB beaten up on Ketanji. Yeah, that was a good one. And Jim, what's up, Jim? Jim is streaming after the show. Oh, the J6 emoji is actually Glenn Croy's picture. I'll share it on local so everyone can see it. Hey, thank you, Just Rhonda, our purveyor of fine emojis. That's Glenn Croy. Man, Glenn, good looking dude out there. Hey, Jim Tells You. Okay, we're going to send some friends over to Jim Tells You, and that'll be a good one. Jim, have a great stream. And Dan says, Fani Willis is old news. She wasn't to be on the case. Judge said no, but Fulton County can be added to the appeals and potentially Supreme Court case in Georgia. Yeah, okay. Yeah, I saw the story was originally back in March, but I think it was the original ruling from McAfee. So I was wondering if there was an appeal or up and down or what was going on. But thank you, Dan. Yeah, we'll take a look at it because you know how we love some Fani Willis, Nathan's hot dog stories here. Oh, those two. The gift that keeps on giving, isn't it? Let's see if we got any other comments, my friends, and then we'll wrap on the day. I am picking up my brother Joey from the airport in just about an hour and looking forward to having him here. Uncle Joey, going to meet our little baby. And he's excited about that. I think he's a little nervous too, but he's going to be great. So he'll be here, and I am sure that he'll be making appearances here repeatedly. Rick D, what's going on? Thank you, Rick. Yeah, Steve Baker posted a big post today. I saw that. I want to respond to that. And Steve Baker, not to give away the whole post, but Steve Baker was on with us on Saturday. We did like 3 hours. And I'm going to re-upload. The first portion of that got cut off because I'm an idiot. So I'm going to re-upload the full thing. If you've already watched it, you'll see a new video, but don't need to watch it again, obviously. But it will be a new video, so the full thing is up there. But anyway, Steve Baker posted about his conversations with a representative called Clay Higgins, who also has a feeling like the Capitol Police were more involved than what they thought. So again, if that turns out to be true, Trump was the sitting president on January 6th. And if the CIA and the Capitol Police set him up, even if Cash and Dan are totally innocent, which I want to believe they are in all of this, and they got duped as much as everybody, that's a big, shocking reveal. Could be true. Could just be wishful thinking. We'll see. But good stuff. Thank you, Rick D. Check out Steve Baker on X at Steve Baker USA. He's blowing some stuff out. So it's good stuff. Rick D. United Farm Workers lose in Ninth Circuit. ICE cannot be enjoined from operations based on past harms. That was in the queue today, but it got bumped. Rick D. Ted Cruz also interviewed Justice Thomas. Not sure where the full video is, but here's a clip. Sounded like a great interview, I know. Clarence Thomas went on Ted Cruz's podcast. Just devastating for me. He has a podcast, it's on YouTube. Thank you, Rick D. Miss Lucky. Sergeant Bob, what's up? Hey, we loved Saturday's program with Steve Baker. What a continuing government cover-up. Miss Lucky and I were incredulous. It makes a good case, right? Yeah. And you don't often get these cases where it's like, well, someone else did it. Well, who? Well, something else it was responsible for. Well, give us some evidence. It's like, okay, here's evidence. She was there on the day. She left work early. Her gait looks exactly like it. Shoe size doesn't match. She's got all these things that a guy like Brian Cole would never wear, like a hat, a watch, these glasses. Then left Capitol Police, disappears, goes over to the CIA. You're like, all right. So a lot of it starts to fit. And it is a curious situation out there, Sergeant Bob. Good to see you. Glad you're still around, and hopefully you're doing well up there in Chino, Arizona. What's up, Tobo? I expect Litters, its side of SCOTUS, is tired of all the extra work the loony left keeps demanding of them. Yeah, I do think that they're probably irritated. Like, they've made some arguments that you do not want to do some of the things these judges are doing. Like they issued an order in CASA, no nationwide injunctions. The judges are still largely doing that. So you got to get tired of that. We've already said this. You guys aren't idiots, lower judges. Like, you know what standing is. So just follow the law, right? Just follow the rules. It's like, how many times do we have to tell you? It is irritating. Mom of many. Hey, Rob and Watcher fam. Hey, thanks for the great stream and good news this evening. I know, so much winning. It feels good, right? I've been mostly out of the loop for 3 weeks. I retired from my day job to homeschool my 4 youngest kids. Amazing, Mom of many. And it's a challenge to carve out time to catch the streams live or otherwise. I'm in a similar position as Alexis, soaking up motherhood, living in the moment, long overdue in my case. I listened to your rationale for your son's name and I love it. Thank you for that. Yeah. I think it fits, right? It fits. I started my own business in preparation for this transition out of the workforce, and I'd love to share it with the Watcher family, but I don't want to impose. What would be good etiquette to invite the Watcher fam to a Zoom meeting, not at a time that you are live? I mean, I would just post it in the locals comment. I would just, add a comment here, and then people can decide whether they want to go or not. I think that's probably the easiest way to do it. So I'd drop a link. Just say, drop your website, drop a link, drop whatever. Probably easier if you don't post a Zoom link, you post like your website, or like a short URL. I would say just drop it. And then if it has to do with like homeschool or something, I might be interested in that because I think we're going to do that with Little Cannon. But that's amazing, Mom of Many. Congratulations on your transition. I think that, just drop a link or, do like King of Biltong, like just send in a comment, whatever. Yeah, we're not too worried about it. Whatever you think is good, we'll read it and send people over there if they're interested. But congratulations. I think, family time is very important. And I miss my little guy. Even when I'm gone for a little bit, I'm like, oh, I can't wait to go just look at his beautiful face. So Mom of Many, I hear ya. And Rick D, and congrats, thank you for the comment. Rick D, Jasmine Crockett's little sister just got booked for threatening to eliminate Governor Greg Abbott. Dang. Man, Jasmine Crockett, full of, wow. So her sister is now going to jail. Well, it's not good for her. Interesting. Keep my eye on that one. Maybe we'll get a charging document soon. I'm sure it'll be good. Sharpie guy, it was Canon and autocorrect got me. Lip load is Texas data centers. Yeah, I think we figured that on Sharpie guy. But thank you for the correction as well. So Sharpie guy. It was Canon and autocorrect got me. Lip load, Texas data centers. Amazing. Yeah, Canon. Canon. Nice. Not like a cannonball, like the canonists, or like a canon, like a body of work, Good stuff. All right, so friends, let's check out what's going on X. Then we'll wrap on the day. Of course, we'll be coming back tomorrow, and we're going to have a beautiful Tuesday. We can just already feel it in our bones. This week is off to a good start. What's going on from Mike? Yes, Mike says, breaking. The Supreme Court clears the way for the election order to go into fruition. Thank you, Mike. Breaking, another one from John Cobb. Democrat judge puts administration on hold until after midterm elections. They just got slapped down by SCOTUS. Mountain, yes, deport Omar and her Somali fraud. Yes, Mountain, 406. No fraud in immigration. If you make a fraud in your naturalization process, it's like any other fraud. You got to go. Jason Williams, come on, Rob. You were live, but no mention of SCOTUS order just handed down? Wow, I'm a total loser. I wish we would have gotten to that there, Jason. Thanks for the heads up on it. Hey, Neuro D, thank you for sharing our locals link, watchingthewatchers.locals.com. If you want to become a member off the YouTube platform, of course, on YouTube, you can click that button as well. And we'll see you back here tomorrow morning, 10 a.m. Eastern time, if you want to get into some other news on the day. And it'll be good stuff. Thank you, Neuro D. We got morning streams. And of course, we'll be back here tomorrow night to get into it all again. And it'll be a good one. Thank you, Courtney Frost, for sending in this little hiding. It looks like a baby to me, but thank you for that. It's great to have you, Courtney. Appreciate the contribution there. All right. And so, friends, we'll pause here for the evening. I hope the rest of your night is just outstanding and beautiful. and enjoyable. Thank you to our amazing mods and meme smiths on the day. Big shout outs to Donut Mind Me. What's going on? To John. We got Muffin Rando. We got K Bean. We got Neuro D. We got Janik and Dog Digger. Geegum, Geegum, Elliot, and just Rhonda, all keeping things nice and orderly around here. And my friends, thank you. Thank you for subscribing to our channel. Thank you for sharing the show with a friend or family member. And thank you for returning here tomorrow, because we will be back. And in order to do this appropriately, we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night. Sleep very, very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light. Watching the watchers defending what's right. Watching the watchers stay each night together and live.